been given. I have challenged the notice where they have threatened me. We shall take over the position if 13.2 not complied with. No, I have never heard of such a law, my lord. 13.2, I have given a reply to 13.2.
So as of now, possession not yet taken.
Position not yet taken, my lord. They have
Threats are coming.
taken an undertaking that we shall deliver position by 25th. By
How
20
can they deliver possession? The sale has to be conducted otherwise.
That is exactly the procedure.
How can it be
Look at the
done?
notice, well. Look at this notice.
A notice has been given.
Notice given.
No, that was at the time of filing of the writ petition.
That notice was given that position will be taken.
Yes.
13.2 on the basis of 13.2.
Yes.
13.2
Thereafter, nothing done.
Nothing done. Nothing done.
What is the item number?
Item number 1579.
Day after tomorrow.
Grateful. Just
Urgent motion. No, it's not required.
May I have your lordship's kind leave to mention, my lord, I had mentioned this matter on.
My lord, the similar method for taking the possession, my lord, tomorrow is the auction sale, my lord.
To auction sale, that means the 13.4 was issued.
So, petitioner, my lord, try to compromise, my lord, at 1 month time, my lord, for some settlement of the bank loan, my lord. So, I pray for, my lord, tomorrow is the date for auction sale.
What is the number?
Number, my lord, and 1777.
1777. Tomorrow.
May I have your lordship's kind leave to
Serve
mention.
notice. Without notice, I will not take up any matter. Your other side should be present. Notice should be served.
May I mention item number 1574, my lord? I had mentioned this matter on the 3rd of March also, my lord. Your lordship's officers had, my lord, recorded, my lord, the number. My lord, this is, my lord, pertaining to the urgencies that, my lord, is pertaining to, my lord, a willful defaulter which has been declared. My lord, violating, my lord, the RBI circular.
No, if the number has been taken up, then it will be listed. Upgraded motion kobe dichen?
But it has no. Not do any banking operations, despite the fact knowing 1574,
1574.
May I have your lordship's kind.
Wednesday.
My lord, may I mention
Yes.
a contempt application, my lord? Contempt.
No inclusions.
Lordships, may I have your.
Inclusion.
It is in the list, my lord.
It is in the list. Why are you mentioning?
Urgencies, my lord, there.
So contempt applications, there cannot be any urgency.
May I have your
Yes.
lordship's kind.
Mention 2 matters for extension of interim orders.
Give them
Upon notice, all orders are next.
so many together.
2, only 2.
2. All right.
Your lordship's kind leave
Extension
to
of
mention a matter, my lord. This pertains to the debarment order that was passed by Coal India Limited on 27th, my lord. The urgency is, my lord, the last date of submission of the new bids under the running contracts is today at 5 o'clock. The bid opening is tomorrow. We had mentioned the matter on 2 earlier occasions. But let's kindly considers this on, kindly grant some indulgence and takes up.
What is the number?
My lord, item 178 in your lordship's.
Daily list?
Daily list, my lord.
178 tomorrow as urgent motion.
Well, it's
My lord.
Serve
May I be-
notice.
it's grateful.
My lord, may I be permitted to mention, my lord, item number 1626 of the monthly list. My lord, the urgency is that I availed some credit facility from the respondent bank against hypothecation of my minibus. After that, my lord, I paid off the entire dues through local adalat. But the respondent is not issuing me no due certificate, my lord.
They will come next month. Nothing doing today.
My lord,
Nothing doing
my lord,
today.
I'm not able to sell my asset. That is the difficulty.
No, come next month.
This is a very serious matter, my lord. I have served notice upon the other sides and mentioning for upgradation, ma'am. Ma'am, my lord, this matter relates to the.
I do not want to know what it relates to. What is the urgency? Why are you mentioning?
My lord, my identity was stolen by a person impersonating me, and the bank and taken a loan against me under my name, and I have no idea.
What is the urgency?
The bank has already proceeded against me before the learned debt recovery time.
Go and sue over there. Yes.
Item number 1565, Lordship. This matter, Lordship, because of illegal mining, Lordship, my house was in a scattered condition. After filing of the writ petition, some more blasts has happened, and now my building is in such a condition it can it just can shatter down any day, Lordship. That is just the urgency, Lordship. We had made representations. There were assurances of compensation or an alternative accommodation. Nothing has been given, because of which the writ petition was filed, Lordship. But after the filing of the writ petition, because of the recent blasts, Lordship, Suddenly there are more cracks in my house and my building is in a very, very bad condition right now, Lordship.
What is the item number?
65, Lordship, of your monthly list.
1565, Thursday.
My lord,
Urgent motion, Thursday.
Lord, for extension of entry modem.
Give-
Lord,
May I be permitted to mention one matter? Under
Grateful,
the
Lord.
adjourned motion, my lord. My lord, kindly take a look at the photographs, my lord. The Imambara, the ingress and ingress is blocked, my lord. The district magistrate is custodian of the records, and my lord is the district magistrate duty bound to see that there is no encroachment in front of the Imambara. But my lord, there is a huge crowd always gathered in front of the Imambara during the.
Oh, why don't you go to the civil court? Why do you disturb the writ court? You can get better orders from the civil
My lord,
court.
kindly, my lord, keeps in the list, my lord. It's an urgent.
No, sorry. Yes, yes,
I'm mentioning 1531.
yes.
The impasse on the works of the directors in the Polygon Skill Studio. But what they are doing it, my lord, a particular parent association, my lord, they are imposing illegal conditions. My lord, if any director, my lord, of a directors association of Eastern India doesn't, my lord, follow such, my lord, illegal conditions, my lord, they are banned. But in fact, nobody works for them. My lord, the petitioner is one of the directors, my lord, who is a member of a, my lord, director association of Eastern India. Now she has been virtually blacklisted because she filed the petition.
Blacklisted by whom?
Blacklisted, my lord, because the parent organizations, my lord, there are 17, 18 organizations, my lord, of technicians, workers.
And the writ petition will be maintainable.
I am satisfied, lord, certainly.
What is the number?
1531.
1531, Thursday, urgent motion.
Lord, may I be
Serve
permitted to-
notice upon all parties.
Already given the-
Even thereafter, since it will be upgraded, please mention because ex parte orders will not be passed.
Certainly.
Yes.
Item number 124 of today's list. Urgency is this at 1 crore 94 lakhs minute I have given in auction sale conducted by Millard the SBI. Now the latest Supreme Court decision says the bank is under duty, Millard, obligation to hand over the physical possession. Millard, I'm not getting it. Millard.
You are the auction purchaser. You are not getting possession.
No, from October 24.
All on a sudden, the urgency crops up.
Urgency crops up means Millard, a day by day, Millard, I have to Millard calculate the interest.
Yes.
And not only that, Millard, the property is in such a condition, Millard, any day, Millard, this can be, Millard, possessed by anyone. Today, Millard, this is not a safe land. But the bank says, Millard, the bank says that we are trying. Millard, I have, Millard, at least observed
Item number
124, Millard.
124, Thursday, urgent motion. 124 of daily list. Daily list. A slip is not required.
Milord, may I be
Daily list.
mentioned?
Hey, 124, ajke
These two matters, these two matters, what happens?
Where are these matters?
This matter I have filed on a last week, Malad.
Yes.
It was not in the list, Malad. What is my urgency is that, Malad, the petitioner has been taken loan from the bank and Malad, the what as per the contractor's start. Malad, now they are
Not getting payment.
payment, Malad, since
So many matters similar. I am not upgrading a single one.
Millard, for
Can't help.
kindly take to this.
No, I am refusing prayers for everybody.
Millard, for withdrawal of the matter,
Yes.
the urgency- the urgency is-
No, yes.
the urgency for this
Ah.
withdrawal is that the order of for taking over a physical possession has been passed.
You want to withdraw the writ petition?
Yes, my lord.
Why? Are you the advocate on record?
I am not the advocate record. I am the counsel, my lord.
Where is the advocate on record?
My lord,
Where is the written instruction from the client?
my lord, we can show that if the matter is listed, my lord. This is not even running in the list.
Where is it?
Probably in the department, my lord. This
Probably in the, what do you mean to say probably in the
matter, my lord, this
department?
matter has not been heard for the longest of period of my lord.
When was it filed?
In 2023.
What were you doing for 2 long years?
My lord, there was no instructions from the client, and now when the
Now, so all on a sudden instruction has come up and
and
you
we
have
have
sprung in
we have
action.
also filed an application before the DRT to challenge that particular taking over a physical possession order, and the learned DRT has observed that since a writ petition is pending before this honorable court, therefore he cannot proceed with the hearing of the section 17 application. And
Give
that's why
the
there is the
slip,
urgency.
non-prosecution.
My lord, I am mentioning one matter very
Yes.
urgency, my lord. I am the service holder of a school. Well, I was the guarantor of a borrower. All on a sudden, my lord, without giving any opportunity hearing, without giving any notice, the bank authority seized my salary account. As a result, I am not drawing my salary. But the borrower is on the ground, the borrower has failed to pay 2 installments. But it is the duty of the bank to proceeding against the borrower as well as against me
but without giving any notice, my salary account will seized. I am the group.
What can be
discharge.
done?
Well,
You have acted as guarantor.
Yes, I am entitled, I am liable to pay. But one thing, my lord, is subject to correction. My salary account will be freeze and the my lord, rupees minus 3 lakhs has been credited in my account. As in when the salary account deposited, it will be minus. So my lord, give me chance to withdraw my, otherwise my group disturbed, I will not running my family. Your lordship, kindly, I have given the notice to the other side as well as the borrower, and they have received the same. Your lordship, kindly give me chance. Otherwise, my lord, the salary will be seized.
Salary has already been frozen.
And
You have,
Please,
yes, what can be done?
your lordship,
Please come next month when the month will start. Please come. Then I will see.
Subject to correction, madam.
No, correction.
No, subject to correction, madam. Since January, I am not, my lord, getting my.
So we are in March. What were you doing? I have accepted mentioning for upgradations
Yes,
of
I am-
everybody who
I am
comes
bound
on the
of
first.
and
Then
your lordship, item number.
today it cannot be done. Yes.
Well, next week I will come.
No. First Monday of the month, please come.
First Monday.
Yes.
Get
My lord, the urgency is, my lord, the petitioner is a widow. Now, my lord, his main source of income is the investment kept by her deceased husband in the public provident fund. Now, this amount, my lord, she has submitted, my lord, the succession certificate. In spite of this, for the reasons best known to the bank, my lord, that has not been transferred. Item 925,
9/25 Thursday. Urgent
I beg
motion.
pardon to
Serve
mention.
notice.
I beg pardon to mention for updation item 590. In spite of compliance of all the formality, electricity has not been.
I do not have electricity determination.
750.
On contempt matter.
No inclusion.
I am disturbing your
Leave. I'm craving leave.
No inclusions. Come on the
I'm
first
craving
Monday.
leave
I'll
to
include.
move this matter. The urgency is that by the competent authority under the West Bengal Apartment Ownership Act, the president and the board of members has been removed. Now, a person has been appointed as the administrator who is the complainant against me. Now, without handing over the charge,
Why you were the
I was the
erstwhile-
erstwhile president. Now he has been appointed as the administrator. And who has been appointed? The person who has complained against me. Now, there are mass deputations against him not to be appointed as an administrator. Second, my lord, though he has not taken charge of the powers or the responsibility, he has freezed our account. The whole apartments owner association has come to a collapse.
Yes.
Subject to convenience, any date may it be moved, my lord.
Where is the matter?
No, my lord, I'm craving leave, my lord. Any day, my lord, subject to my lord's convenience.
Friday it will come.
Friday.
Serve notice. Leave granted.
May I have my lord's kind leave
Grateful,
to
my lord.
mention, my lord, under compelling circumstances, a restoration application.
No, madam.
My lord, may I only apprise my lord of the urgency?
No use. Restoration means you permitted the matter to get
My
dismissed
lord,
for
it
default.
was dismissed
for
on that
any
day,
reason.
my lord, when there was a resolution.
Any
Originally,
reason
the Bar Council had
whatsoever.
called for a cease work, my lord. My lord, the only difficulty is the entire SARFAESI action is illegal. There has
I
been
am not allowing your prayer for restoration, so do not go into the merits. When I will take up matters first Monday of the month, please come, I'll accept.
Lordship, may I be permitted to mention these two matters pending since 2022 and 2023 to be included as listed motion?
Sorry, sir, today is not the day for inclusion. Come on the first Monday of the month.
Lordship, on the last occasion I came, but I did not get the opportunity to mention before your Lordship on the first day of this month.
Why did you not get the opportunity?
Lordship, it was too crowded. Lord, I did not get.
So this time you enter early, so you'll get the chance.
Well, under compelling circumstances, I am mentioning this matter for lordship, item number 110 of today's daily list, my lord. The petitioner is a 78 years old person who has won the case against him lodged by the ED in the year 1996. He has won in trial court, high court, and as well as the apex court. But the parallel proceedings of adjudicating authority was not moved by his learned counsel because of some miscommunication. Presently, the amount which was seized on that period of time is amounting to rupees not less than 2 to 3 crores. He is in such a position that his family is in a ailing position and there is no money left with him. My lord, I have made an RTI application. There is no reply whether the case is pending with the adjudicating authority or not. The case is not found in the adjudicating authority also, my lord. That is why the bank is not releasing the money. But let it be.
And the first appeal, second appeal, all provisions
He has won before the Honorable Apex Court also.
with the RTI?
No, with the main case of the criminal proceeding.
The RTI, you made an application, then the first appeal and the second appeal, All provisions you have complied with?
But I have just made an RTI application, but no reply has come till.
Then how can the writ petition be entertained?
But are we satisfied, Your Lordship?
No question of satisfaction. There is a statutory provision. Please avail it. Yes.
May I kindly be permitted to mention, Lordship, item number 1242.
No, I accepted one of your mentioning. Please don't.
Lord, I have mentioned this matter on 3rd March, while Your Lordship was pleased to keep this matter on any day. Lord, since the matter has not been appeared, this matter is running as item number 765 in the monthly combined list, my lord.
Your mentioning was allowed?
Yes, my lord.
Then it will appear. Do not mention again.
Lordship, for extension of interim order.
When is it
It's
expiring?
expiring on 31st of this month.
Give.
May I
May I
hear
have
your
your
lordship?
leave to mention item number 88 of the lordship's list. Matter relates to an application filed under section 14 of the SURFACE Act. Despite the lapse of more
Who are
than
you?
3. But I'm for
Bank?
the yes, my lord. In more lapse of more than 3 months, my application has still been kept pending. If
Yes.
your lordship has passed an order, even given a directions to the Registrar General to notify all the district magistrate, my lord.
Yes.
We have communicated even that. Even then also, my lord, no date for hearing has been given as yet, my lord.
Which is the item number?
88, my lord.
88 Friday. Serve notice.
Yes, ma'am.
May I have your lordship kindly to mention one motion matter, my lord. The petitioner is not getting the payment against the UTI mutual fund, which he needs badly for the his high
Where is the
studies.
matter?
My lord, it has been the order has been passed by single judge in favor of the petitioner, my lord. But the division bench, my lord, directed the single bench again to hard again, my lord. One his father made an party, my lord, because his father requested the UTI, my lord.
Where is the matter?
My lord, this matter is disposed of by the single bench, my lord.
No, it went up in appeal. The court directed for rehearing of the matter. Where is it now? Has it been
My
listed?
lord,
When was the
on 7th, 9th July 2024, it was on RD section, my lord.
it was in the RD section?
Yes, my lord.
24.
24. my
And
lord.
when was the order passed by the division bench?
The date.
Prior to that?
Yes, my lord.
Prior to that?
Yes, my lord.
So from 24 till 25, what were you doing? You mentioning it in the midst of the month? Today it cannot be done. Yes.
Lordship, I am mentioning one matter for inclusion,
No,
Lordship.
sorry, don't.
May I be permitted to mention one matter? This matter is, my lord,
For what?
for upgradation, my lord.
No, don't mention.
Lordship, may I have permitted to mention, my lord, matter relating to Swatantra Sainik Yojana scheme. Petitioner was getting pension under the scheme, but suddenly her pension has been stopped.
Yes.
The matter is running in the list, my lord, as in the combined list 1333.
1333, when did you file it?
Lordship filed.
Mention when the mentionings are taken up for upgradation. Please mention then.
My lord, kindly.
I like to mention one matter, my lord. I have mentioned this earlier, my lord. The event is that Vishwabharati has constructed a wall in front of my property, my lord, and they are actually blocking the entire drainage system. I have intimated them that the drainage system is sealed and the complete wastage and the water is completely spilled over the land. And my lord, I have already, my lord, intimated them, but they are not taking any steps, my lord. It is
So
going
why
for
are you before this bench?
my lord, because the authority is Vishwabharati, my lord, and they are constructing the wall without any authority, my lord.
Who is supposed to see that the drainage system works properly?
Municipality, my lord.
Which municipality?
Bolpur municipality.
Right. Why are you here? Why are you not before the municipality bench?
My lord, but I have intimated them as well, but they are stating that
Please,
it is
this
not.
is a matter to be taken up by Group 5 bench. You please go there.
My lord,
If the matter is here, I can release it. Which is the item number?
my lord, item number 113 and 111, my lord, of the daily list.
Matters.
Two matters, my lord. The properties are
113 and
113 and 111.
111. You are the advocate on record?
Yes, my lord.
Please take down, release for want of determination.
My lord, may be permitted
Five,
to mention a
Group
matter.
5 matter.
Be permitted to mention a matter, my lord, for upgradation, my lord.
No, please don't mention.
Ma'am, I had filed one writ
Please
petition.
Please wait. Yes.
Lordship, may I be permitted to mention a matter for the inclusion?
No, no, no.
Lordship, it was
Yes.
made returnable on 12th March only. It didn't appear since then in the daily list.
Returnable on 12th of March.
March.
It has not appeared. Give the number. Yes, please. No, not today.
Your Lordship, may I have liberty to mention one matter? 24.
What is your prayer? Yes.
Lord, may kindly grant me leave to mention a matter for upgradation, my Lord.
No,
My
not
Lord, this-
today. Correction? What is the correction?
The respondent number 5, respondent number 5 are appearing and their name has not been recorded.
I will give. Are you mentioning something? What?
The upgrade, but
No, don't mention.
If the upgradation is not granted, my lord, my petition will be infractual.
Nothing doing.
Ma'am, I had filed a writ petition
Yes.
till
Yes.
But I for WBIDs.
My lord, I appear on behalf of the petitioner, my lord.
Lordship, Lordship, I appear on behalf of the state, Your Lordship. The affidavit has been made ready. It was not affirmed because of my license, Your Lordship. There was some medical emergency back at my home. So for that reason, it will be affirmed tomorrow and I will serve it tomorrow itself, Your Lordship. This was at my instance that the affidavit was not affirmed, but it was finalized, Your Lordship. If Your Lordship just grants me one day, it will be affirmed tomorrow itself. Or maybe today in the afternoon only. It was because of my license. I have informed my learned friend.
My lord, in that circumstance, my time to file the reply may be extended for a period of 2 weeks, my lord.
Last occasion, see, it's recorded peremptory extension.
Your Lordship, this is before Your Lordship, it was because of my latches.
because there was a medical
All
emergency.
that is not a great thing to be placed on the prayer of the learned advocate representing the state respondents. Time to file the affidavit in opposition is extended till day after tomorrow.
Grateful, Your Lords.
It will be open for the petitioner to file reply to the same within a fortnight.
Within a fortnight, my lord, the difficulty is I met with an accident yesterday, last night. I will be in bed rest for another 2 weeks.
3 weeks. 3 weeks?
3
Or
weeks. No, my lord, 3 weeks will be more than enough.
3 weeks.
If your
Then-
lordship
Yes.
kind of fix a date, my lord.
This the matter
Grateful, Your Lords.
after conclusion of the aforesaid time period. Yes. You are
Great.
there for WB.
WBA. So, my lord, we have filed our affidavit.
Yes, yes, IDCL.
With
But I'm for the petition.
Myself to appear for the contempt, my lord. Copy this out, my lord.
Is it appearing for the first time?
My lord, appearing for the first time, my lord.
How are you appearing? Notice has not been served
Sir,
also.
no, my lord.
No. My instruction, my lord, they had intimated me, my lord, to appear, my lord. That's
All
it.
right.
Let a copy be served, my lord.
Which copy will be served? Has the order been complied since you are already appearing?
Just now,
For my instruction is, my lord, order is not complied, my lord. There was only an order, my lord, to take an hearing and pass a, my lord, rescind order.
Hearing not taken.
Hearing, my lord, concluded, rescind order not passed.
Please come. The petitioner complains of violation of the direction passed in the order dated 6th May 2024. Stop, let copy of the contempt application be served upon who to serve? Upon the contempt or upon you?
Well, upon me, my lord. That's why, my lord. The overphone intimate.
Achha. Upon Mr. Fazlul Haq, learned advocate, who has instruction to appear on behalf of the contemptor. Stop. The contempt application stands adjourned till 21st of April. Stop. An affidavit of compliance shall be made ready and served prior to the adjourned date.
Good.
I am for the Your Lordship, the writ petitioner.
Bank.
Bank.
I appear for respondent number 6, HDFC Bank.
7. Sybil.
The Sybil and Your Lordship, the HDFC Bank, both are here.
I see Reserve Bank is also a party.
The Reserve Bank, Your Lordship, is also a party, but we are concerned about, Your Lordship, the Sybil and the HDFC Bank. Because
Did
the
you
reason
serve Reserve Bank?
Your Lordship, I find, Your Lordship, earlier, Your Lordship, an affidavit of service has been given.
Yes.
But, Your Lordship, there was a direction to serve all the respondents. I find, Your Lordship, they have served only one.
Respondent number 4 and 6 was represented on the last occasion.
Lordship.
That means Sybil is there and 6, the bank is there.
Is there, Your Lordship.
But the
What
relief
is-
which has been sought for is against the RBI, my lord. because
Reserve
the-
Bank?
Order has been passed by the Reserve Bank. Your
Yes. So
Did you not serve upon
petitioner
the
has
Reserve
sought for
Bank?
I think
setting
mistake
aside
has been
the
done,
order
Your
of-
Lordship. I checked, Your Lordship, the affidavit of service. I could not find, Your Lordship, because on the last occasion, Your Lordship directed all the respondents to be served.
Yes.
Because earlier it was served, but last time, Your Lordship, only one respondent has been served. Your
Please
Lordship.
serve in that case. Now represents the Reserve Bank of India. Stop. Let service be made upon the non-appearing respondents. Next Monday.
Has been served, Your Lordship. It is
Served?
Reserve Bank. 15
And-
NS Road, Your Lordship, kindly sees.
Receipt is there?
Yes, Your Lordship.
Track report?
Track report is here.
Very well. Then it is all right. What is it?
Lordship, kindly come. Your Lordship, may I cut short the matter what has
Yes,
happened?
please.
This is in connection with Your Lordship, the Sybil, Your Lordship knows that if I, Your Lordship, don't pay the loan or there is an outstanding, then Your Lordship, my civil scores reduced. And it is affected, Your Lordship, regarding my loan taking capacity. Now, Your Lordship, kindly take the order under challenge. Page 163.
Yes.
Page 163, Your Lordship, the Reserve Bank of India found that before Your Lordship initiation of any proceedings, Your Lordship, under CIBIL, later has to, your grievance has to be gone before Your Lordship the concerned bank. Otherwise, it will not, Your Lordship, as per the Ombudsman scheme. Your Lordship, that's the exact order has been passed. Your Lordship, kindly sees the complaint has been closed. Please refer to your above captioned complaint filed with our office. We have carefully examined the captioned complaint and the observations are given hereunder. The bank, viz. HDFC Bank, has submitted that as per the record, it has not received any complaint from you and the referred issue prior to the escalation of the office of the RBI Ombudsman. Further, it is observed that you have not attached the proof of written electronic complaint and or opportunity to the bank to reply the complaint. So that's why, Your Lordship, on that basis, the complaint has been closed. But prior to that, Your Lordship, my grievance is, Your Lordship, it has gone, Your Lordship, to HDFC Bank. Your Lordship, kindly take once. Your Lordship, page 87.
What is the stand of the bank? Did you receive the complaint?
Your Lordship, no.
Page
No?
8, I am showing Your Lordship.
Where is
Page,
the seal?
Yes, Your Lordship, page 87. And now, Your Lordship, kindly take, Your Lordship, this particular letter has been dispatched and they have received it. Lordship, kindly take page 101. And when I made a complaint before the, Your Lordship, the RBI.
But this is 101.
Item delivered to Kolkata GPO, my lord. I could not find whether it has been served on bank or not.
Right. Where is the service on the bank?
Lordship, item delivered to the addressee, page 101.
To the addressee, Kolkata GPO.
Kolkata GPO.
Current status, item delivered to the addressee.
Delivery location. Kolkata
Out for
GPO.
delivery office.
My lord, delivery location is Kolkata GPO.
I don't know, Your Lordship, because their office, Your Lordship, is in 8 Netaji Subhash Road.
Kolkata, under the Kolkata GPO.
May I take instruction on that, my lord? Because from
Is
just
this
it's
your
not-
prayer for consideration of this representation?
Now, Your Lordship, what happens? This representation has gone. CIBIL replied to this because not only Your Lordship.
Civil replied to this.
Yes, page 87. And thereafter, Your Lordship, CIBIL, on the basis of this particular representation, page 104, CIBIL actually had, Your Lordship, given me a reply, page 104.
Yes.
But HDFC Bank, their main Lordship, the order, crux of the order is, I have not approached the bank and that's why your complaint has been closed. So today, I'm not before Your Lordship regarding, Your Lordship, the adjudication of the complaint. My grievance has gone before the HDFC Bank. So you cannot close the complaint. Reason is, Your Lordship, when I make the complaint,
Let her come back and say whether you have received it and whether any steps were taken. Please come. The petitioner is aggrieved by the closure of complaint by the RBI Ombudsman on the ground that the complaint was not forwarded to the HDFC Bank Limited. Stop paragraph. Learned advocate for the petitioner asserts that the complaint was forwarded to the bank and CIBIL, CIBIL. Stop. The CIBIL replied to the complaint, but the bank did not. Stop paragraph. The track report of the subject communication addressed to the bank evidences that the postal article was duly served upon the bank. Stop paragraph. Learned advocate representing the bank is directed to take instruction with regard to the steps taken in response to the communication dated 17th September 2024 made by the learned legal representative of the petitioner. Next Monday, released next Monday, 24th. ওটা থাকবে আচ্ছা, let further notice যেটা বললাম ওই জায়গাটা লিখে দিন,
May I be allowed to
let
serve
this
reserve
order
bank,
be communicated to the non-appearing respondent.
Lordship.
Affidavit of service taken on record.
I'm grateful.
I'm for the petitioner, my copy served and affidavit of service is there. Actually, my lord, this petition is for the benefit of this entire, to even petitioner and even for respondent. Why I'm saying, your lordship? So, my lord, I was the my lord grantor of this my lord corporate debtor, and my lord corporate debtor goes into liquidation. But subsequently, my company also goes into liquidation, my lord. So, still it is expanding before the NCLT under liquidation, my lord. So, in the meantime, my lord, good sense prevails between the bank and the petitioner. So, my lord, they were at the verge of the settlement, where liquidator published this, my lord, at page number, your lordship, page 14, my lord. So, page 14, liquidation, my lord, published this for the sale of that my company, and subsequently, my lord, since my lord, this due to amendment of the IBC, I am entitled to participate. So I am the highest bidder. So I am going to purchase my property. So this thing, my lord. So in the meantime, your lordship, that may be due to non-coordination between the different wings of the same bank. So my lord, page number 18, your lordship. So my another wing has declared me a willful defaulter, your lordship, as my lord. This page 18, your lordship. So, my lord, so in this bid, my lord, I have deposited 1 crore rupees. So, still thereafter, my lord, I've stated on affidavit. My lord, continuously, we remained sitting in the meetings for 50 days, almost, my lord, that how to overcome these things, my lord, that since a willful defaulter, if a person is declared as a willful defaulter, he cannot purchase his own company. Though I am a MSME, otherwise I can purchase my own company as per IBC, your lordship. So, my lord, thereafter these meetings and subsequently, my lord, the bank also realized that, my lord, when they issued this notice, this page 18, your lordship, my lord, I was the grantor. So, my lord, this notice has been not served upon me. My name might be written on that notice, but the bank, if the bank can able to show this notice has served upon the grantor also. My grantor is my lord, this thing your lordship, I'm not denying that.
What about the borrower?
Borrower has nothing to do. I'm not concerned with the borrower, my lord. Okay, see, presently, I am the grantor, though I am liable to pay, and I am paying that, my lord. Because I'm.
But then, if the borrower pays it, then what is the requirement of payment by the guarantor?
No, borrower has been placed into liquidation, but that entire amount might not have been recovered. So, my lord, I am also in a liquidation. So, I am willing to pay this rest of the due. And my lord, this is the RBI circular. This is just come up 5 days before, your lordship.
Yes, then, but then without the other side.
Yes, my lord, the thing is, your lordship, only this, that matter. When you are declaring the borrower as a willful defaulter, whether you are required to serve upon the notice also a grantor when you are declaring the grantor too as a borrower defaulter, my lord. So they may be under misconception that only grantor can be automatically become liable as a willful defaulter. My lord, RBI has cleared by the 10th March. This
Let me see.
Actually, my lord, this it may cleared on 10th March 2025, your lordship. So, your lordship, kindly
When was the notice?
Paragraph number 3, my lord. Paragraph 3.
No, this was in December 24. At that point of time, 10th March was not there.
No, my 10th March was not there. And your lordship, one thing has become they must refer the judgment of the Honorable Supreme Court.
Yes,
which have the
Rajesh
retrospective
Agarwal is there.
just affect, my lord. This, my lord, my amount has returned on, my lord. Your lordship, see, my lord, kindly page number 20. This page 19, my lord. This is a letter of liquidator to me, page 19. Here, my lord, concerned paragraph is the paragraph number 3, your lordship. Paragraph number 3, my lord, in the last line, this is saying that person as a willful defaulter in all the cases, even include the grantors also, my lord. So even in the cases of willful defaulter, my lord, I am entitled to a notice. So your lordship, kindly see my petition, my lord. Paragraph number, my lord. My lord, paragraph number 8, your lordship, kindly see, my lord. I've stated that thing, my lord.
You saw once more and come
Yes,
back.
my lord, I will serve it, your lordship. Otherwise, my lord, this even if your lordship, even if it be kept in
respondents, show me your service once.
Oh, my lord, this is.
নিয়েছে দেখুন তো।
My lord, it's supposed to be filed at that time.
Where are the track reports? 4th of March, you've put it to post. Track reports, you didn't get it.
My lord, actually,
By this time, it should have been there.
yes, it was my lord, filed same day, my lord. I mistake. I will serve it again, your lordship.
Yes,
Yes,
none represents the respondents. Let notice be served upon the respondents intimating that the matter will appear in the list on next Monday, 24th.
Monday, my lord. Grateful.
Affidavit of service is taken on record. Taken on record.
Your Lordship, I am for your Lordship, the petitioner. So I have served your Lordship the copy to the Reserve Bank, your Lordship. That's authority, your Lordship, which floated the tender.
And the track report, is it there?
It's a hand service, your Lordship.
Hand service. All right. What is your grievance?
My grievance, your Lordship, I have been declared, your Lordship,
See
ineligible.
hand service বলছে তো রিজার্ভ ব্যাংক ঠিক আছে
My grievance, your Lordship, is that I have been, your Lordship, declared as ineligible, your Lordship, in connection with your Lordship, a tender floated by the Reserve Bank of India. This particular tender, your Lordship, is in connection with the supply of certain medicines to the dispensaries of the various banks of Reserve Bank. Now, your Lordship, kindly take your Lordship once, your Lordship, the tender that starts from page 20. Now,
can it be done in the absence of the other side?
It should be good, your Lordship, if the other side is there, because
serve a notice and
only
come
my
back.
one problem, your Lordship, that if it can be taken day after tomorrow, because this technical bid, your Lordship, have been declared as unsuccessful, and they will, if they issue the financial bid, open the financial bid, I would be in problem. May come, your Lordship, day after tomorrow, so that I can
Very
serve.
well. None represents the respondents despite service. Stop. List day after tomorrow, 19th March.
19th March, your Lordship.
Let further notice be served.
Actually, in the meantime, if your Lordship, some protection so that your Lordship, they will not proceed with the tender any further.
No, I have not heard it, so
I
mechanical
understand.
orders cannot
May
be
come
passed.
back. May come back.
Victor, appear on behalf of the respondent number 1.
But I'm for the petition.
I'm for the statement.
Matter was dismissed for default on. Lord, I don't know.
Restoration of the restoration application.
Restoration, but neither of the applications has been served upon me. Neither of the application has been served upon me.
You've not served the state. And how is restoration of restoration permissible?
Because the learned advocate on that occasion of
Legally, court is asking the legal.
28th February, when the restoration application was taken up for hearing, the learned advocate who was appearing of
That
the
is it,
petition
got restoration.
remained absent. That is why.
Remained absent, I can understand.
Yes.
But why will it be allowed?
There is the client will.
And how come you didn't serve upon the respondents?
So many respondents, my lord, income tax authorities also.
Bank 3 received
Bank
and the
received.
income tax department that has been returned as insufficient address. Lordship may kindly seize.
Is the state a party?
Yes.
In the cost title, I do not see the state as a party.
Police. Commissioner of police, my lord, respondent number
Charge.
Yes.
and my respondent number 2, commissioner of police.
Commissioner of police.
All
Who
have
did you serve?
Through post upon the respondents. But the
To post upon the respondents. And the order which was passed dismissing for default, I can see the appearance of the learned counsels there, and you will not serve upon them. What type of practice is this?
there is mistake.
It cannot be done. Serve.
Yes.
And then whether it will be allowed or not is a different thing.
Lordship.
Please come. Learned advocate representing the respondent submits that copy of the application has not been served upon them. Stop. Let copy be served.
Oh, no, it has been served upon the respondent number 1.
Very well. Upon 2 and 3, not served.
Copies, my lord.
Copies.
Copies, my lord, because
Copies.
the previous
Very well, copies.
application has not been served, my lord. Only this application I have received.
And then income tax department.
Lordship, that has been
That restoration, no,
that has
restoration application.
returned due to insufficient of address.
It's your fault.
Advocate appears there is perhaps no.
No,
use of
income
service.
tax officer, income tax department, government of India. I do not know. Ministry of Finance, who is going to appear? You have to ensure service.
Yes, Lordship.
Copies of the writ petition. Next Monday.
Applications, my lord.
Yes, applications.
Will appear on.
Next Monday, 24th.
Great.
Thank you. Seven and 8 both are, my lord, the paradise matter.
7 and 8, both. That Paradise matter. কোথায়?
My lord, I appear for the petitioner. I have already served a copy of the fire safety certificate upon the responsibility state.
My lord, only one thing you have mentioned this matter. They have opened the shop without your lordship's consent. That we have mentioned, my learned friend mentioned this matter. Your lordship, please to fix this matter today. It is a glaring example of violating your lordship's court's order.
Yes, state.
In spite of, my lord, so the division bench said not to open it without the license.
That is true, my lord. We already, my lord,
Don't have.
inspection, my lord. We have sent, my lord, their application to expert committee, my lord. As per expert committee, my lord, opinion, my lord, we send some protocols are there, my lord. If they are fulfilled their protocol, my lord, we have issued the, my lord, fire
They will
certificate.
issue. They will issue. Not yet issued.
1 minute.
No.
If or have you issued?
No, we will issue, my lord. If
You
they
will
have,
issue.
yes, my lord, they have complied with their, my lord, our, my lord, all the, my lord, obligations and, my lord, terms and conditions, my lord.
They have complied.
No, never.
Complied.
They have not complied.
Under process, my lord. We
It
are
is still under
requirement,
process.
my lord.
Who is permitting this authority, this petitioner to open the shop? What
Well,
steps
I
are you
don't know.
taking?
My lord, we are the fire safety, my lord, department. As per, my lord, fire safety norms, my lord, they made an application.
Try to understand one thing.
My lord.
Have you issued a no objection certificate or not?
No.
Somebody is opening the shop. What steps will you take?
Yes, my lord, we already, my lord, previous occasion, as per lordship's order, my lord, they are stopped their, my lord, shop.
They have again opened it.
My lord, we will take steps, my lord.
Why is every time somebody have to come to court and say, see, somebody is doing something illegal? Why will you not take steps on your own? The moment you get to know that somebody is doing something without your consent and without your no objection?
My lord, we will take steps.
What
my lord.
yes?
No, my lord, kindly, my lord, appreciate, my lord.
Nothing to appreciate. If there is a law, it is to be followed.
My lord, definitely, my lord.
Take steps.
Definitely, my lord.
My lord, one submission may I make, my lord? I appear for the writ petitioner, my lord, in the second matter appearing, my lord. My lord, last occasion we had handed over, my lord, a copy of the fire safety certificate issued by the
1
government,
minute.
my lord. That is
The
what
here the learned counsel for the state submits that the permission is yet to be issued. It is still under process. This is what his submission is. I do not know.
my lord, only one submission. Last occasion we had handed over, and my learned friend has a copy of that document, which my lord had directed them to take instructions on.
Yes,
this is the document
this
issued
is what
by
the instruction is possible.
Certificate what
Whether
is
that has
issued,
been
my lord,
or not, my lord.
upon the self-declaration by the party, my lord. And that is, no, there is a format, my lord, that has to be inspected. But after inspection, the authority, if authority found that there is illegalities, they can cancel it out. So that happened, my lord.
So what will you do? You have got a copy of the e-challan or what, something that has been given to you. What is the step taken?
My lord, there is a common format on the online
I have
portal,
followed that.
my lord.
Thereafter, what is to be done?
Thereafter,
Can
inspection conducted, my lord, and we found some irregularities. And say upon that irregularities, we have mentioned that irregularities we have found. So you have to regularize all these things. If you regularize all these things, then we can issue.
Not yet regularized?
No.
Kindly once look to the report. It cannot
I have
regularize.
filed.
It is for the authority.
No, right. This report, I am not saying anything else. Report says there is a lacking at least 25,000 liters underground storage tank. That is
That
impossible
is already
to construct.
done, my lord. We have already complied with
why
it.
I
We've
am
given a
saying,
letter
na,
to
you
the
say
authorities,
that.
my lord,
Let them
showing
go
that.
and inspect
Yes,
and
my
see
lord. Let them
whether it has
Of
been.
course, my lord.
My lord.
Till
We'll
such
try
time
to-
you will not open it.
But they are gone and see.
That's the report.
No, no, no.
Who are you for?
I put the respondent number 50.
Who is that?
We have segregated. Same. We have segregated.
Petitioner, who is in this petition? Respondent number 50.
Whatever. And who has given you the permission? You filed.
My lord, the permission is because of, my lord, I'll indicate why. No, no. My lord, let me indicate why, my lord. My lord, the fire safety certificate by way of an online declaration can be obtained by me pursuant to the notification that is being relied upon by Mr. Basu itself. It says, my lord, if the height of the
Wait,
portion
wait,
of the
let
building,
them go and
let
see.
them go, my lord. Only one further submission, a factually incorrect submission today has been made, my lord, that we haven't complied with it because after the report, my lord, taking cue of all
Whether
the
you comply or not comply, it's not for the court,
lord.
it is for the authority to go and see.
My lord.
Let them go and see.
We had given them a letter on 11th
Prior
March
to that,
itself, my
do
lord.
not open because they say there are irregularities. Now, if something,
there is
God
no-
forbid nothing happens,
Yes,
but
my
if
lord.
something
Yes.
happens,
My lord,
why take this responsibility? Why create problems?
My lord, by today,
Safety
tomorrow, whenever
hazards.
they want to inspect, my lord, there is no issue.
Saying that 11C applies.
No.
When will the fire authority go?
My lord, we have submitted that why we are considering this building as a because this is
Court is not concerned. Say yes or no. They will run their business or not.
No, my lord, not now because we have stopped that business because before that we have
After the copy of the online permission was handed
my
over
lord,
to
there
you.
are two writ petitions. First writ petition, they have challenged that petition challenged that license is not actually sanctioned by the authority. Second writ petition, while we have found they have challenged that how they could stop our business. Now after that we have inspected and we found that irregularities are there and whatever we made in our representation that has been challenged in the second writ petition, that is right. So now there is the order that has not been stayed that they can go with the business or not.
Give the second writ petitions copy.
My lord.
The number.
The first one is my application.
Yes.
First petition the segregate for first petition tate আর second petition tate second petition tate second petition tate
There will be no application filed before the Supreme Court.
And these are not perishable goods. Why are you in so much of hurry?
Today, Malad, we kindly consider 50 employees. 50 employees, their jobs are at stake.
You
Malad.
run your business, but you obtain licenses and permissions and then do it.
My only submission is after the report, after the recommendations made by the fire department, we've taken steps. Let them inspect today itself, Malad.
So prior to an inspection, how could you continue?
Malad, because after the report, we had applied on the online portal. Pursuant to the fire recommendations, they had issued, the government of West Bengal has issued this fire safety certificate. On the basis of this, this is a subsequent fire safety certificate.
We are not considering this self.
Corporation, is anybody there?
Corporation is not a party in my.
Who is not a party here?
No.
That another writ petition.
That's
But
a
the
separate writ
change
petition
has been
pending.
struck down. There is no change. There will be no change.
That has been already an interim order has been passed by the
That
court
is,
in a
Malad,
bench,
interim
Malad.
order
That
is-
cannot, let Mr. Basu not
No,
make any
interim
comment.
order,
That-
what is interim order? Not to take any steps without leave of the court. So this cancellation of conversion has not been stayed.
The interim order does not say so, Malad. I'll indicate. I have the interim order. I can have.
134 of 2025. In this writ petition, they have challenged the memo that
134.
134.
That's item 1.
The
Please
steps
come.
we have taken, the preventive steps we have taken,
Preventive steps.
and they have challenged that, my lord, in this step. তোরা সেইগুলো preparation একটা ইয়ে করবি। হ্যাঁ, এইটাই।
Self-clarification.
Because this was
on correct premises.
So this fire safety certificate and report is subsequent to all of that. The impugned
is correct.
It's all subsequent.
The
All on a subsequent cause of action.
My lord, in this writ petition 23.
business of the petitioner. Running from 39 Bentic Street, Kolkata 70069, is without a proper fire safety certificate. Stop. The fire and emergency services are to inspect the property to ascertain as to whether the same complies with the fire safety norms. Stop paragraph. The department is directed to conduct inspection to ascertain as to whether permission can be granted for running the shop. Stop paragraph. Prior to the same, the petitioner shall not run the business. Stop. The matter is made returnable on next Monday, 24th. Stop. Learned advocate representing the Fire and Emergency Services Department shall come up with up-to-date instruction.
Only one prayer, my lord. My lord, only one prayer, my lord. If my lord kindly considers, my lord, there's presently, my lord, we're approaching Eid. My client is in the business of selling garments, my lord. This is the prime time, my lord, where we have to ply our business, my lord. 50, my lord, all the.
Understand, today is Eid. Tomorrow will be another festival. Day after tomorrow,
I
further one.
My lord, only we.
Let them see whether there is a fire safety.
Let it be before then, my lord.
No,
They
it cannot rush.
My lord, in our report, we have stated that there is no fire safety
Opposition to
measure
what?
they have taken. Yes.
Opposition. In which matter? 7 or 8? Item number 7. Keep his
My lord,
opposition on
my lord,
record.
kindly just record my submission, my lord. Only my submission that we have
The
complied.
opposition on record.
Only my submission, if it could be recorded, my lord,
Which
that we have
submission?
complied. We have complied with all the recommendations in the report.
Whatever
Only
said
that
is
submission, if it
there.
could.
Yes, call the list, please. Record everybody's presence.
Grateful.
Oh, Act. Yes.
My lord, in this matter, the petitioners have been identified as willful defaulters by the Willful Defaulter Identification Committee without an opportunity for hearing. 4 previous dates, my lord, the Willful Defaulter Identification Committee postponed the hearing on ground of administrative reasons. Only one effective hearing took place in which I attended. And that hearing, the matter could not be concluded, the matter was adjourned. Thereafter, they shared a forensic audit report with me saying that we are going to rely on this additional document. The matter kept getting adjourned. 4 days after that, the matter was adjourned because of their administrative reasons. The mails are there. Now, my lord, I filed a writ petition before this honorable court, assailing their right to rely on this further addendum report. This honorable court was pleased to dismiss that writ petition, saying that you have a right of audience before the Willful Defaulter Identification Committee. Whatever grounds you want to take, whether it can be relied, whether it is incorrect, correct, you do that before the Willful Defaulter. So that writ petition got dismissed. Then we went back to the Willful Defaulter Identification Committee. Willful Defaulter Identification Committee gives me one notice of a hearing on 15th of September. Before that, I informed them. I'm a senior citizen, my lord, aged about 76 years. Petitioner number 1. He was the chairman and managing.
Read petition copy dekhi.
He was petitioner number 1, was the chairman and managing director of the company. He was at the helm of affairs. He suffered a fracture and he was incapacitated, my lord. He was advised complete bed rest, not to move around. With that medical prescription of a hospital, my lord, I sought for an adjournment. My son is the petitioner number 2. He also sought for an adjournment, saying no effective purpose will be served because my father was at the helm of affairs. My father is praying for an adjournment. Please grant an adjournment only for this date and defer the matter for 15 days. That prayer for adjournment is not considered, and I'm identified as a willful defaulter. Now,
So practically, you did not get an opportunity.
I did not get an
hearing.
Yes, I did not get an opportunity of a hearing after my lord. The forensic audit report was relied upon. Prior to that,
and final order was passed on when?
My lord, final order, I'll just tell you, lordship.
14 September 2022.
14 September 2022, when we moved this writ petition, my lord, an ad interim stay was granted, considering the facts that I did not get an opportunity for hearing by a coordinate bench, of course, my lord, that I did not get an opportunity for hearing, and on the past, several hearings were adjourned at the instance of the.
But there is a review committee, isn't it?
Yes, my lord. So what happens is, my lord, once the default is identified, there are 2 steps, my lord, as your lordship knows. One is the identification committee.
So you say you lose the first step.
I'll lose the trial. I'll lose the trial. Yes, my lord. Not the first appeal. First appeal is there. The review acts as the first appeal. But I lose the trial, my lord. Then the trial is the identification committee, my lord, assesses the facts of the matter.
Lordship,
I'm sorry.
This issue has already been decided by coordinated benches. Similar matters.
Which issue?
This issue, whether, at this moment, if they have been declared as identified as a willful defaulter.
Now, this is where he stands up and says that no, the identification was not proper.
No, that's not correct. I'll come to this point. But what it truly transpired, there was an outstanding loan of about 800 crores in this company. The company was taken to CIRP by the financial creditors. Now,
During the course of the CIRP, a transaction audit was carried out, a forensic audit was carried out. In that audit report, which is called the addendum report, it was pointed out that the directors have been willful defaulters. They have diverted the funds, and the report is very clear. I can take you through the report also. Now, what happened?
No, were they given proper opportunity of hearing?
See the orders also of the
Because he says that his father was in the petition
to the show cause notice. They had replied to the show cause notice.
Hearing.
And after the show cause notice, their reply was considered. And thereafter, your lordship, an order was passed.
Considered without hearing them or after hearing them?
I'm trying to explain to your lordship is this, that this is just this is not the final order, you know.
Right, it's not a final order. So you hear them once again and then pass final orders?
This is the review committee is the final authority, your lordship, to decide whether they are actually willful defaulters or not willful defaulters.
Sir, why will they lose one forum? Give them one hearing and then finish it off.
Lordship, an opportunity was given. It's not that what my learned friend is saying. If you kindly see the brief.
Show the hearing portion?
A portion, yes. Kindly see, lordship. I'll first take you through the order.
No, don't take us through the order. You show the hearing that
okay, I'll take
effective hearing was given to the petitioner.
I'll explain. I'll take it. Kindly look at your lordship. Let's page 14, para 27. I will take you.
Show the annexures, please.
Page 18. Page 18. Show me which page is it? Page 18. I think it's. I'll just take it to the annex. Page 263, your lordship. It starts from there. We refer to the notice dated 20th October 2020 issued to you to show cause and make submission as to why your name should not be included in the list of willful defaulters as per RBI guidelines. The Willful Defaulter Identification Committee is pleased to offer you an opportunity for personal hearing to make your submission before the committee. Accordingly, if you like to avail the said opportunity, you may make your submissions through video conferencing arranging at SBI. Please note that the above opportunity is for making your personal submission, if any, in the matter, and the lawyer, chartered accountant who are not partners. So please bring your PAN card numbers. So this is one letter which was issued. Subsequent to your lordship, kindly look at the next page, your lordship, at same letter. Then the next page is 16/9/2021. With reference, this personal hearing again. This was issued to Rahul Tatia. With reference to your letter number, this dated on the caption matter, we have to inform you that due to administrative exigency, the personal hearing is scheduled on 23 has been postponed. So it was postponed. Thereafter, your lordship, again, so kindly look at page 304. Then there was an opportunity given to a learned friend at 304. Open it. On 304. So here, your lordship, kindly see 304. This was issued by IP Tatia. I'm in receipt of your above cited letter received by me on 31/8/2022. I regret to inform you that while walking, I have suffered an injury on my right foot and ankle on 8/9/2022. The doctor has advised me not to stand, walk, dangle my leg for at least 15 days and to keep the leg in an elevated position on a pillow and to apply ice compress thrice daily. Under the circumstances, I will not be able to attend the personal hearing called by you a good office on 14/9/2022. I request to kindly fix it. I regret that he is enclosed on this. Then again, your lordship, a letter was issued by Rahul Tatia, who is also the petition number 2 here. A notice for personal hearing is to be held on 14/9/2022 at 10 a.m. has been issued to me as a father IP Tatia. As per the letter written by you, he will not be able to attend the hearing if the matter is requested. So thereafter, your lordship, kindly see next page 307. Inclusion of the name. Please refer to the show cause notice sent to you as per the directions order of the Willful Defaulter Identification Committee dated 28/10.
So there is no hearing.
So there was, lordship, there was a proper submission made by them.
Oh, where?
Kindly see the order.
Page 304 you read out just now. The petitioner number 1 requested you to adjourn because 14th of September 22 it will not be possible for him to attend.
308, your lordship. This 307.
308.
So here we say, your lordship, in this connection, the Willful Defaulter Identification Commission has examined the representation submitted by you. In the personal hearing, your reply as mentioned above and rejected your submissions.
Where is the personal hearing?
So There was no personal hearing, Your Lordship. There was a reply made by them. Now, I'm only praying, Your Lordship, kindly see the orders which have been passed by the coordinated benches. It's very clear. Similar matters, Your Lordship. Kindly have a look, Your Lordship. Same matters.
The petitioner
Lordship,
is aggrieved by
just
the...
give me a moment.
Yes, please.
Kindly see these orders. Similar matters where... Huh? Yeah, sure. Similar matters where again a director of the same company, borrowed company, had filed a similar writ petition. I'll give it to you later. I'll just give it. Just give me a copy of it.
Paragraph 1, Your Lordship, says personal hearing was given.
Learned counsel for the petitioner contends that the petitioner was an erstwhile director of the defaulting company but was roped in for declaration that the petitioner is a willful defaulter. It is submitted that although the petitioner was given a personal hearing and the petitioner had filed a specific and detailed reply to the impugned notice.
How is this same?
It is the same, Your Lordship.
How can it be?
Same cause of action.
Listen, please.
Lordship, same
Petitioner was given a personal hearing.
Kindly
This
see,
is
Your
what is recorded.
No, it is
Here in this case, at the personal hearing stage, an adjournment was sought for.
Lordship, isn't this a duplicacy of what my learned friend is trying to say? Lordship, there is the same set of directors who are actually directors of the corporate debtor. Wait, they're the same directors. The coordinated bench has already held that this order which has been filed by the Willful Identification Committee is correct. But they say, okay, don't worry, there is a review committee who will ultimately decide whether you are a willful defaulter or not a willful defaulter. So my learned friend, if he really wants to make a hearing, he can make an application or a submission before the review committee, who will ultimately decide whether they are actually willful defaulters or not, Your Lordship.
Sir, this is a submission of a respondent. Had you been in the same position of the petitioner, would you have made the same submission?
Lordship.
You are losing a forum. It's just a matter of forum. Your willful defaulter committee can pass the same order all over again, but just giving him an opportunity of hearing.
I appreciate that because this matter had been lingering for a long time, Your Lordship. That is the reason.
The matter was filed in 2022. You could have taken steps.
Absolutely.
Because you are the bank.
Yes.
You are losing money.
Yes, absolutely.
You could have taken steps. Petitioner is enjoying an interim order. He'll be that way.
So may I submit in that case?
Yes, please.
If Your Lordship is actually giving directions, then let directions be given to the identification committee to dispose it of within 15 days. And they let them appeal.
Absolutely. This submission could have been made at the very first beginning. I am continually saying from the first time, giving one hearing, finish it off.
I appreciate it. So kindly give them directions also within 15 days to dispose.
Absolutely. Even if it is within 10 days, do it. But let them be heard. By the order passed by the Willful Defaulter Identification Committee in identifying the petitioner as willful defaulter. Petitioners, willful defaulters. Stop. It appears from records that a notice for personal hearing was given to the petitioners, intimating that a hearing will be held on 14th of September 2022. Stop. A request was made by the petitioner number 1 to adjourn the hearing because of medical emergency. Stop. The identification committee proceeded with the hearing and declared the petitioners as willful defaulters. Stop. The same is impugned herein. Stop. Paragraph. Though it is true that there is a review committee to review the order passed by the Willful Defaulter Identification Committee, but since it appears that the petitioners practically did not get an effective opportunity of hearing at the very first stage, the court is inclined to give one opportunity to the petitioners before the Willful Defaulter Identification Committee. Step next. The petitioner will lose the forum for identification if this opportunity is not granted. Step. The same will amount to violation of the principle of natural justice. Step. Paragraph. To comply with the provisions of natural justice, a peremptory opportunity of hearing will be granted to the petitioners. Stop. Paragraph. the respondent authority is directed to grant one last opportunity of hearing to the petitioners to defend themselves. Stop paragraph. The petitioners are directed to cooperate with the hearing by the Willful Defaulter Identification Committee. Stop. A decision shall be taken by the committee afresh, positively within afresh at the earliest, but positively within 4 weeks from the date of communication of this order. Writ petition stands disposed of.
4 weeks or
Earliest. At the earliest, outer line is 4 weeks. It's your time.
My lord, may I only pray for one further direction, my lord? I should be given at least 7 days notice, prior notice of the hearing, my lord.
All right. 7 days prior notice of hearing shall be given to the petitioners.
Grateful. Deeply obliged.
Grateful.
Item number 1, my lord. I'm not pressing this application, my lord. The petition.
Where is the on record?
And he is the on record.
All right. And
It's there from the petitioner, ma'am. But,
what is the issue?
But she has just written that Ami Anjana Chatterjee, Shami such and such, আপনার দ্বারা উপরিউক্ত মামলা হাইকোর্টে দায়ের করিয়াছিলাম, বর্তমানে এই মামলা চালাইতে ইচ্ছুক নই, আপনি দয়া করিয়া এই মামলা হাইকোর্ট হইতে উইথড্র করিয়া লইতেন।
Simpliciter withdrawal.
My lord, only the liberty I am seeking, my lord. This matter, my lord, this is the matter to refer before the DRT, my lord.
If permissible in law.
Yes, yes.
If permissible in law, kindly mention
Yes,
that.
yes, madam.
Because
Such
the
liberty I am
period of limit.
Pressed. Stop. Petitioner prays to approach the debts recovery tribunal. Addition hobe eta. Stop. It will be open for the petitioner to approach the debts recovery tribunal in accordance with law. Communication to be taken on record.
My I'm filing the
For the petitioner.
communication letter, ma'am.
Yes, yes.
And the block letter.
Well, I'm not pressing this application with liberty to file afresh because
Why?
there are certain mistakes. Because prior to this is for the bill, he's a government contractor.
How
and
could you file the writ petition in March and you did not notice the mistakes?
Well, prior to filing of the writ petition, a bill was given to the petitioner. That was not communicated to the to me by the petitioner. There was a miscommunication between the petitioner.
Do you follow what are the repercussions? Anyway, incurable defects, leave granted. Dismissed, leave granted. Next.
Personal appearance of the IU, my lord. This was
Personal appearance.
This was regard to a warrant issued by the trial court in respect of 138 matter, my lord.
Yes.
That was supposed to be
Which person is present?
My lord, IU is present. I see, my lord. I see.
Yes.
My lord. So the accused person has been arrested, my lord. But arrested, my lord, but not in connection with this case, but in connection with another case. Now we have shown this accused as a shown arrested in respect of the warrant issued by.
When did you arrest?
My lord, that arrest was done on, my lord, 12th March of this month, my lord.
After order is passed on the 10th, on 12th, the OC becomes hyperactive and goes and arrests.
This OC has joined this, my lord, police station recently, my lord.
How recent?
There are many.
And still the OC could not find him to go arrest.
What happened, my lord? He is not interrogation. He is moving around. Ultimately, he has controlled from the move down.
You mean to say that the OC is not going to arrest?
There is a delay, my lord. Unfortunately, we have to admit this, my lord. Admittedly, there is a delay. Admittedly.
And the High Court has to interfere only for getting a person against whom 45 warrants of arrest are there.
This is something which is very Milord, sad to.
Not sad. This is alarming. And your client should know how to behave. This is not the way how he is to stay in the position of the OC.
But he has, not that.
What is the further relief that you are seeking?
My lord, kindly see page number 30, page number 49, the order of the Honorable Court earlier occasion, and the order summons served on page number 31.
Now the summons have been executed.
Milord,
Nothing remains in the writ petition.
Milord, now that, Milord, there's one issue only, Milord. There's one issue, Milord. Now that as soon as he was arrested, Milord, his health got deteriorated and he was admitted to a hospital, Milord.
There are steps to
Milord,
be taken.
Milord,
Take steps.
That steps will be taken, Milord. According to law, we'll take steps, Milord.
Please come. What is the name of the officer concerned?
Milord, Shotinath Chatturaj.
Please put it down in a piece of paper with proper spelling so that it can be recorded in the order sheet. Such and such person, officer in charge, Madhyamgram police station, is personally present in court. Stop. It has been submitted that the accused person has been arrested, though in connection with a separate case. Stop paragraph. It has been brought to the notice of this court that as many as 45 warrants of arrest are pending execution against the accused person. 13. Tarokhana.
Since 2017 onwards.
Stop. It appears from records that order was passed by this court way back on 15th of June 2022 to take steps for execution of the warrant of arrest. But for reasons best known, the said person could not be arrested. Stop. Immediately when direction is passed by the court on 10th March 2025 for personal appearance of the officer in charge of the Madhyamgram police station, the accused gets arrested on 12th March 2025. The police shall take steps in accordance with law to deal with the accused person.
On page 54, the case is pending before the learned first judicial magistrate. Page number 54. At the top, the case number, and bottom is the confirmed code.
Stop. It is recorded that the instant writ petition arises out of a proceeding pending before the learned trial court, being CR 102/17. Take down all these. Acha. REG number 230/2018. CNR number টাও লিখে নেবেন। ঠিক আছে? Stop. As the relief sought for by the petitioner has been allowed, nothing remains to be decided in the instant writ petition. Stop. The same stands disposed of.
I'm grateful.
Personal appearance dispensed with. Same order.
Case number is separate.
Case number is separate.
Case number is at page number 47.
Yes, report taken on record. Case number telephone.
May I have a copy of the report?
The detailed report I have is terms of the lordship's order.
It's a 3 number report.
In the last page, my lord, if in
may I have a copy of the
CR? Yes.
The order.
CR which 160/2017. Page number 50. REG number টাও দেখে নেবেন, CNR number টাও দেখে নেবেন. Report is taken on record. আর কোনোটাই চেঞ্জ হচ্ছে না।
Arrest, my lord,
সরকারের order
been shown arrest in that tribunal, in the court below, my lord.
Same order date.
Get
Report is taken on record. Give a copy to him so that he can see what is there. Yes.
Illegal excavation of sand
Milord, I am for the status.
from Murakhi River Millet, the petitioners before your lordship Millet at the residence of
In
the
the earlier matter, may just indicate one thing, Milord. Till date, Milord, he has arrested on 12, Milord. Till date, Milord, because of Milord, he is in hospital and hospital didn't discharge him for production before the court below. If he can produce virtually, Milord. If that
You obtain order from the learned court below. Why?
Landed SCJ, Milord, pass an order, Milord, Milord, they have not able to do anything. This police officer gone regularly there, Milord, from 12th onwards, Milord.
Yes.
But till date, Milord, the court says, Milord, today the concerned police officer, so-and-so, Moddomgam Police Station, District so-and-so, appeared before the undersigned Executive Magistrate, Barasat Subdivision. The warrant was not produced, procured before the undersigned. As per statement of the IO, the warrant is under the warranty is under treatment in Arjikar College and Hospital. As such, the identification of the warranty could not be done due to non-production of the warranty. The IO concerned produced documents related to the arrest, vide CR case number so-and-so. And
you can make all your prayers before the learned trial court.
It has been prayed, Milord. It has been also prayed for virtually because the hospital, unless I'm not.
Just he
But
has
that
been
is
arrested.
not been
Just
allowed.
how can it can
One line, if only one
Just
line.
getting
is
added,
added.
fast at all.
Nothing will be added. Take steps before the learned court below. No.
Fast,
Nothing. Yes.
Millet, illegal excavation of sand from the Murakhi River. Consequent thereto, Millet, there is a dam which has been introduced or given by the central government, and the excavation is adjacent to the dam. Consequent thereto, Millet, there is a direct threat to the foundation of the dam, and the petitioners before your lordships are the residents of the locality, and they are having their lands immediate beside another side of the dam. So if these illegal activities are being continued, Millet,
And it is being done by the respondent number 7.
it is being done by the respondent number 7 and others.
And the respondent number 7, are you aware whether he has a license for?
Millet, he has no license. That is my instruction. Only issue is this, Millet, in the vicinity there is an area. In a particular DAG number, there is a license. That is in particular DAG number 2661 or 26631. But Millet, the activities, the illegal activities is continuing beyond that particular.
All right. Where is your complaint before the authority?
Millet, my complaints are starting from page 46 onwards. Millet, the first complaint I have, although it is addressed to the Honorable Chief Minister, Millet, but
No, where is the complaint to the DM?
Millet, the same complaint has been forwarded. If your lordship kindly come to page 46, the copy of this complaint has been forwarded to the.
Show me the receipt.
Millet, the receipt your lordship will find from page 49. Millet, the page 49, Millet, the lordship would kindly see the first postal receipt, Millet.
Track report.
Millet, the track report is annexed. I have, Millet, that is the next one. 89.
What is the instruction?
Milord, immediately after receiving the complaint, Milord, we have conducted an inquiry, Milord. Your lordship kindly comes to page 3 of my report.
Yes.
For once. Page 3. The BLLRO, Milord, was intimated, Milord, to whether without any permission, Milord, the sand was being excavated or not. Your lordship now kindly comes to page 7 of my report, Milord. Page 7, clause 3.
Yes.
List of running 23 sand blocks. This is Milord, the register of the sand blocks that was collected, Milord. 1, 2, 3. Clause 3, Milord. HON'BLE Nivas Private Limited, Calcutta, having office at 37 Diamond Harbour Road, Milord. He has got the permission upon 1.4 hectares. Now your lordship kindly comes to page 9, Milord. Page 9.
And the lease agreement starts in 23 and it is for how many years? It's yearly.
Well, it is for
yearly.
5 years, Milord.
5 years?
5 years, please. 5 years, though. 5 years. Now your lordship kindly comes to page 9, Milord.
Yes.
Page 9. Here is the Milord. Mr. Hanif Sheikh, he is also implemented as one of the respondents, my lord. He was authorized. We hereby authorize you to carry operations and coordination work at our sand block, so and so, under Bharatpur Police Station, Murshidabad, as per following terms and conditions, my lord. Now, your lordship kindly comes to page 51. The report of the BLNR, my lord.
Yes.
Page 51. From inquiry, it appears that excavation of sand was from plot number 2631 and 2669 of Moja Tolgram of so and so. The part of the mentioned plots were leased out in favor of HON'BLE Private Limited. The embankment on northeast side of the river is about 100 meter, and embankment on southeast side miles away from this site of the excavation sand. The depth of sand excavation is 7 to 10 feet. This is for your information.
What does this mean? Can you identify from this as to whether this is, as he is saying, causing any harm to the property that they are occupying, whether the embankment will
The property
endanger
they are
or not?
As far as the embankment issue is concerned, my lord, that comes under the purview of public interest, whether the bridge or the barrage is being damaged or not. But as far as, my lord, illegal excavation is concerned, my lord, we have made the inquiry, and, my lord, we have found that they are doing it in terms of the license granted to them.
Whether this mining, illegal or not, is causing any damage to the embankment, who is going to look into it?
We haven't found anything like that, my lord, because
There is nothing.
No, my lord, because what we have found that the excavation is done miles away from the barrage.
100 meter, not miles. What do you say? 100 meters
300
away.
feet, 300 feet, my lord.
Yes, the embankment of the river is about 100 meter.
And, my lord, we have also found that the
is about
excavation
100
plot is the part of the land which is a
embankment
leased out
on which
property.
miles away from the site of excavation.
Subject to correction, although I have not got the report from them, if your lordship kind enough to consider, since they are saying that the excavation is in accordance with law, if your lordship be kind enough to consider the sand rules of West Bengal, Rule 9, Sub-Rule 3.
5. Page 54, page 5.
Within a distance of 2 kilometers of a barrage access or dam.
Access or dam on a river.
Yes,
So,
but
Millet,
this
the-
is neither a barrage access nor a dam.
It's a dam.
It's an embankment. Is it a dam?
It's an embankment, Millet, given it's under the Kandi master plan. The whole purpose is to prevent the flood in the area. Now, Millet, the consequence is this. Millet, the dam has a different interpretations. One dam is a barrage where the water
is stored.
Water is stored. The another part of dam is also the embankment given to prevent the flood. That is also a part of the dam. So, Millet, my contention is this: the nature of the firstly they
are. Please come.
I mean, if your lordship kindly comes to page 5 of the writ application, my lord, the issues basically pertains to the Green Tribunal, my lord. Moreover, the erosion caused by the illegal sand extraction threatens the surrounding ecosystem, water quality, agricultural land.
The petitioner alleges that the private respondent is carrying out excavation of sand illegally. Stop. A complaint was lodged before the respondent authorities, and the same not being responded to, the instant writ petition has been filed. Stop. It has been submitted that the mining activity is not in line with the rules published in the Kolkata Gazette Extraordinary on 31st January 2022, being the not being under the nomenclature of the West Bengal sand bracket open mining, transportation, storage and sale bracket close rules 2021. Stop.
What has not been dealt in the
Rule
application.
9 within bracket 3 of the aforesaid rules has been placed, which mentions that no sand mining shall be carried out within a distance of 2 kilometers of a barrage axis or dam on a river unless otherwise permitted. Stop. Learned advocate representing the state respondents relies upon a report forwarded by the officer in charge, Bharatpur Police Station, signed on 14th of February 2025, which includes a report from the inquiry report from the Blockland and Land Reforms Officer, Bharatpur 1, Mushidabad, dated 12th February 2025, which mentions that excavation of sand from plot number 2631 and 2669 of Mouja Talgram, jail number 42, is being done by Ambe Nivas Private Limited in terms of the lease agreement. Stop. The embankment on the northeast side of the river Kuyo, K-U-Y-O, is about 100 meter, and embankment on southeast side is miles away from the site of excavation. Stop. The depth of sand excavation is 7 to 8 feet.
10 feet.
7 to 10 feet. Stop paragraph. The Blockland and Land Reforms Officer, private respondent likhe din to. Learned advocate representing the private respondent submits that the mining work is conducted in accordance with the lease agreement. Paragraph. The Blockland and Land Reforms Officer, Bharatpur 1, is directed to cause further inspection upon notice to the petitioner, the private respondent, and all other necessary parties to assert as to whether the provisions of the West Bengal sand bracket open mining, transportation, storage and sale bracket close rules, 2021 are strictly complied with or not. Stop. Released the matter on 8th April.
Right, full minute. Extra minute.
Service দিয়েছে? Did you file the affidavit of service?
The affidavit of service filed earlier, because this matter was initially moved before my Lord Justice Ghosh and released therefrom.
The provision which has been agitated my learned friends, the West Bengal mining mineral rules, which is dealt with the lordship, this code number 2, the land matters. The land matters.
Yes.
Cannot be a lordship, your residuary matters is falling.
Anything under the sun falls under the land matters. No difficulty with that. Call the next matter.
I am for the petitioner in this matter, but there is an application for being added as a party. But once I see Mr. Kaur, probably he had forgotten that 30th of January 2025, at page 50 of the writ petition, he appeared for my client. But
That is a separate
No,
matter.
no, identical.
altogether. There is a subsequently, there is a fresh tender.
I don't know.
I will not say anything. I can see your name recorded for the petitioner
my client,
Santosh
but
Bhagat.
there were two
Here is also, I do not know.
But there were
It
two
is
petitioners.
up to you.
I tell your lordship, there were two
It is up to
petitioners.
you. If you feel it's all right, I will not say anything because professional discipline is required to be maintained.
So that
This 25 supply is going on, which is on a tender.
I do not
which
know.
is a subject matter. He moved it according to his move, my lord. The new tender notice has been given, which is a subject matter of challenge here.
Today you represent one party and tomorrow you fight against him.
But,
I don't know. It may be a different contract.
No,
I do not know.
I represented Lord two petitioners, and Lord I succeeded in getting the terms of the tender, Lord, quashed by your
two.
lordship.
I see only one over here.
There were two petitioners.
See from the order sheet.
No, no.
Kindly, Lord,
Only Santosh.
Santosh Bhagat, I do not see another written over there. Whether it is an error or not, I do not know.
No. Vishwanath was never with.
Vishwanath was not there.
Not
I agree. Vishwanath.
He is appearing against.
But this is a completely new
Yes, what
tender.
is it?
My lord, the tender notice, my lord, that was given initially at 2023 was divided by, because we had equal tenders. Lordship may kindly come to page 19 for once with regard to the supply of the food. My lord, District Magistrate Murshidabad. Lordship will
Which
get
page? Which page?
Page 19, 19.
All right. Yes.
District Magistrate Murshidabad's order, my lord. Two tenderers were found eligible, that is Vishwanath and Santosh. They are having the rate with the tax at 183.75. Therefore, 50-50 ratio, my lord, it was distributed between these two persons. The remark column. Has your lordship got it?
Yes, for us.
Kindly turn next. We had no, my lord, idea that the conspiracy is being hatched up. Kindly look at page 20, next page, page 20. Now, while you are giving the distribution in equal ratio, page 20 itself will show very first paragraph. As far as you are approved carrying contractor, you are requested to receive a so and so quantity of the rice for the first quarter. Vishwanath is getting 21,000. Santosh is getting 16,000. Not equal distribution. I did not mind that, but I did not know that this will fall upon me at the later stage. Page 21, my lord. Again, the second round of supply. Vishwanath has been given 26,330. Santosh given 19,000 quantity, quintal for supply. Next one, my lord, is 19th of August 2021. Vishwanath given 22,203. Santosh given 14,907. Fourth one also, page 23. Vishwanath given 31,804. That was in November 21. Santosh given, my lord, 22,926. This is how, my lord, is continued up to page 24, 25, 26. Lordship will up to 2023. Lordship will get it page 27. Vishwanath has been given 14,000. Santosh given 11,000. Page 23, 27. Now, my lord, the new tender came. It continued, my lord, even up to page 29, page 30. Every item of supply that this discrimination continued. Now, my lord, second tender was given in respect of the supply of the food. Kindly come to page 35. Condition was imposed. Why the condition which affect us is, my lord, clause 7, next page, page 36. Which ultimately, my lord, affected us, but I am just simplifying that clause, which is, my lord, required to be fulfilled. The intending tender as clause 7 at the bottom, my lord, penultimate paragraph probably it is. The intending tenderer should produce credential of a similar nature of completed work of carrying food stuff for the last 5 years for an amount of rupees 80 lakhs only. The intending tender, but kindly, my lord, this is important. Intending tenderer should produce credential of similar nature of completed work of carrying foodstuff for the last 5 years for an amount of rupees
80 lakhs. So it is for 5 years I have to my lord show that 80 lakhs I have dealt with. And second one is a 60 lakhs for each year. Or alternative. Value of the work of carrying foodstuff for the last 5 years or for an amount of 60 lakhs only for each of the carrying 5 years. Now kindly my lord skip it over. My lord, you were found rejected. Page 41. Both Vishwanath and myself have been found rejected. Page 41. Rejected. Ground of rejection is technical, not the financial issue, technical issue. Kindly mark it. The technical issue, my lord, we were rejected. Very well. Now, next tender came, my lord. Tender number 3, page 43. My lord, the dropping date is 4th of February. Leave aside that. My lord, condition at page 44. My lord, 7.1, same condition, verbatim condition. Intending tenderers should produce, page 44, produce credential of a similar nature of completed work of carrying foodstuff for the last 5 years for an amount of rupees 80 lakhs. Intending tenderers should produce credential similar nature of 60 lakhs. Identical. This same condition maintained. Well, this was also, my lord, rejected. Not admitted, page 49. Not on financial issue, my lord. Santosh at page 49.
Yes.
2 bidders only found. Not admitted. Pre-qualification, technical. Technical qualification is disqualified. Both are disqualified on the same score. Then writ came. For me, for my client, it was moved. Page 50. Where we said, why did this writ was filed? Writ was filed, my lord, for condition that you are imposing certain condition which is so rigorous that none of the persons who are participating in such tender can fulfill the technical requirement on the part of the tenderer. So we wanted that condition may be relaxed as per the finance rules. Finance rules also speak for that the rigorous such condition may be relaxed in order to enable someone to participate in tender and to get the tender. Well, for that, the writ petition was filed, page 50.
Yes.
The writ petition related to a notice of tender, my lord's order.
Yes, then what happened?
Of 3 of NIT, 3 NIT was challenged. Dated 7 January, the same pertains to carrying contractor of foodstuff for lifting of the rice forfeited FCI godown.
Yes, thereafter what happened?
This order of your lordship, my lord,
30th of January.
Passed, my lord, lordship asked them to consider the representation relating to relaxation. Now, my lord, comes the final order at page 55. 55. Kindly come to page 56, which is the subject matter of challenge. My lord, where 80 lakhs was a matter to be considered within 5 years transaction, it has been made out that 80 lakhs is to be considered for each year. More rigorous. Kindly come to, my lord, page 56. The age clause 6, Roman 6. Has your lordship got it? Roman 7a. Roman 7a. Intending tenderer should produce credential of a similar nature of completed work of carrying of foodstuff for the last 5 years for an amount of 80 lakhs only for each year. This has been inserted. Why this each year has been inserted? This is with a motive to give a premium to this particular Vishwanath, who was given, instead of 50-50 ratio, higher quantity of quintal was allowed to supply, where he reached to the 80 lakhs per year, where we could not reach for 80 lakhs per year, for a particular year. In the earlier, lordship will kindly come to the earlier condition. This particular condition was not there. At page 44, if your lordship kindly pays a look. Once again, the intending tenderer should produce credential of a similar nature of completed work of carrying the foodstuff for the last 5 years for an amount of rupees 80 lakhs. Where each year? This was not a condition prevalent there. None of the years, earlier also, my lord. And in the second call, in respect of the same tender work, my lord, this work has been given the for each year what has been inserted only to make one person eligible, that is Vishwanath in third call. In the third call. In the third call. My lord, distribution of the quantum has already shown to your lordship. 50-50 ratio has not been maintained, only to give a premium to him in future, so that you are the only person who will continue to supply this. But whether this particular insertion of a new clause in the second call of the said particular tender, whether allowable or not, where the court directed you consider his representation where relaxed conditions should be applied. Finance finance condition in identical issue. তুমি যেটা দেখাচ্ছিলে আমাকে একটু আগে may I place the finance department's memo? 3rd December 2021. Lordship, excuse me, I did not know that he had no second copy for this. I had marked it somewhere. Kindly excuse me. This is the identical cases where the persons are not eligible to participate because of the stringent condition imposed by the tenderer. Where the finance is saying you are to consider relaxation.
Survey is free with a copy.
তোমাদেরই order তোমাদেরই order সব নিয়ে আসবে ফাইন্যান্সের order.
কপিটা স্যার
ফিনান্স ডিপার্টমেন্টের অর্ডার, গভর্নমেন্ট অর্ডার।
কপি নেবে তোমার কাছে নেই?
কি দিচ্ছ তুমি? এটা জজ সাহেব যেটা দিয়েছি সেটা তো না। Where the number of qualified bidder is less than 3.
এটা তার সাথে যেটা দিয়েছেন এটা সেদিনই হচ্ছে চলো প্রিন্ট করে আসতে।
And date is last date for filing. We are disqualified. Last date of filing tender matter has been fixed to 18th, not 2. Is 18th of March. According to the NIT themselves. আমি বলে দিয়েছি Mr. Kaur cannot appear in this matter. He appeared for myself. You cannot join for Vishwanath now.
What are you relying on?
The finance department's notification.
Yes.
That has been stated there that in case of where the number of qualified bidder is not is less, and if the condition is so, the authority should consider whether conditions should be relaxed, palatable to those who are participating.
Did you raise an objection before the tender inviting authority?
But we came out before, my last date was 16th. I had no time.
My lord.
We have made a representation at page 88, annexed at page 61. Request to revision of financial criteria, so and so. We have given representation to the district magistrate who has received it also.
The authority concerned deleted the classification class. According to the final settlement, the modification is actually controversial. The second time, the second tender notice is at page
Second tender notice
43.
43.
Yes, this was under challenge in the earlier writ petition.
Yes.
Right?
Because none are getting being technical, all are technically failed. প্রত্যেক বাড়ি তাই হয়েছে, এইটা তো ডিসকোয়ালিফাই হয়েছে। That there was actually ground of challenge was the new condition inserted in third tender, third notice, second notice, that clause 8 was given, the registered distributor, page 36, if your lordship kindly pays a look. The registered distributor and food supply department are eligible to participate in the tender process even if they don't fulfill the terms and conditions. This was a discriminatory condition for which the matter was moved before.
On the basis of the order.
1 minute. 1 minute. Yes.
But kindly come to the.
Who is appearing? I oppose his appearance. He cannot appear.
I tell you,
let him not appear.
No conflict of interest. Just give me 2 minutes. If your lordship still feels
No.
that there is a conflict.
I will not say anything.
Lord,
It is
we are opposing.
up to your conscience.
When I
My
accepted
client
whether
paid
yes.
him.
Lord, when I
How can he
accepted
appear
the
against
plea,
me?
I had Lord checked up whether Lord there is any conflict of interest. I'll just Lord explain in 1 minute, and I'll not.
For
take,
whom
Lord,
he is
more than
appearing? For whom he is
7th
appearing?
January.
For whom he is appearing? May I
It-
put a question to myself?
Had it not been him, somebody else could have appeared. Why?
No,
upon the advocate
no
concerned?
party is there. Vishwanath is not a party here.
There is an application for addition.
Addition of party application will be taken care of. Vishwanath's presence is not required in the context of the present
2
case.
minutes, my learned friend will hold his breath for 2 minutes. Lord, 7th January
I do not know
25.
what is
If
going
your
on.
lordships kindly take page 43, the what was under challenge is clause 8 at page 44. Because 7 and 8 were conflicting. So, Lord, your lordship's order, which is
Very well. As on date, you are not representing the petitioner, you are representing the
respondent. Now, Lord,
which respondent? You are not a respondent.
I have made an application.
Application for addition of party. Let me see. Well, please
Lord,
wait.
just two more minutes. Just Lord, I just wanted to say that your lordship's order, Lord, ask the district magistrate to consider whether, Lord, this clause 8 and 7 both should remain. Lord, now the fresh notification has come. Your lordships will see 7 has been retained, 8 has been deleted. Your lordships may kindly, Lord, take.
Yes, I have seen that.
7 has been retained, 8 has been deleted. So, Lord, today
you do not have anything to say?
I don't have anything to say on clause 8 being included, etc. I have nothing to
So
say.
don't, what is your application for?
My application is that, Lord, the tender should go through because, Lord, 2021 we were allotted. And Lord, we are continuing on that old rate.
We means including him.
Including him 50-50.
Yes.
Whatever grievance
So
he
you
has.
want him to be there also?
No,
Why not?
I want a fresh tender.
Why?
Lord,
Why?
if it is joint again, Lord, we don't mind, but Lord, the rates are going to be revised because 21 rate can't continue in 20.
That is for the authority to decide.
Correct. Lord, therefore, Lord, that fresh tender has been invited.
Let me see. Please. I have seen your instruction. What does this say? Clause 6.
The basis of the order of the Honorable Court, the authority concerned deleted the relaxation clause.
And for that reason, deleting the said clause, tender committee issued tender notice.
So it is according to you, this is the continuation of the same tender notice,
Second tender
right?
notice.
That is so,
And finance rules, that third call is not permissible.
right?
And third call is not liable. Tender is not liable.
And so you treat this to be as a continuation of the second one,
Yes.
right?
Yes.
Please come.
As because the writ petition has never challenged the credential power.
You never challenged the credential. Was it required to be challenged?
Yes.
Was it required to be challenged?
In his previous writ petition, man.
Was it required to be challenged?
As because petition has no capacity.
Yes,
He has no capacity.
he has no capacity. You say this is the same continuation. Please read out the earlier clause and read out the new clause. Do you think they are the same? You take these people for a ride. Ligunto.
Lord, may I have my lords kindly?
Yes, please. And your application is being dismissed. This is what I'll record.
Very.
The instant writ petition has been filed.
My lord, kindly record, my lord, the tender committee has no absolute power to impose tender condition. As the writ petition has no right to interfere.
Whatever is here, I will not record anything extra. Right? Achha. The petitioner is aggrieved by the act of the tender inviting authority in imposing and inserting new clause in the third call of a tender notice. The first tender notice was invited on 26th September 2024. With the 2024, stop. One of the terms and conditions of the notice inviting e-tender was set out page 36, 7, Roman 1 and 2, bracketed portion. Puro 7 ta. There were 5 bidders and the bid filed by all 5 stood rejected at the technical stage. Stop. Second notice inviting tender was floated on 7th January 2025. Stop. The aforesaid condition was also a part of the terms and condition of the retender notice. Stop. A writ petition was filed at the instance of the petitioner, being WPA 1395 of 2025, challenging the relaxation which was given to the registered distributors of Food and Supply Department, being clause 8 in the notice inviting e-tender and notice inviting re-tender. Stop. The court disposed of the writ petition by granting liberty to the petitioner to file a composite objection before the district magistrate and collector, comma, district within bracket ICDS cell, comma, Murshidabad, to agitate his grievances by highlighting the alleged discrepancy in the tender document. Stop. It appears that an objection was raised by the petitioner and the authority considered the same and floated further notice inviting e-tender within bracket re-tender dated 24th February 2025. Wherein the relaxation clause, which was incorporated in the earlier two notices inviting e-tender, stood deleted. But surprisingly, a new part was inserted in the existing clause 7 of the earlier notice inviting tender and retender. Stop. The notice inviting retender dated 24th February 2025 records the following 7 set out. Acha. For each year, this portion should be in italics and in bold. ঠিক আছে? The learned paragraph, the learned senior counsel representing the petitioner submits that the expression within quotes for each year made the terms and conditions of the tender more stringent, and the same restricts participation to most of the bidders. Stop. It has been submitted that the said portion has been inserted only to suit a particular bidder who was supplying, who was awarded the contract along with the petitioner in the earlier period. Stop paragraph. The work orders issued in favor of the petitioner for the earlier period are annexed to the writ petition in support of the submission that even though the authority directed that both the tenderers will execute the work as per 50-50 ratio, comma, the quantum of work allotted to the tenderers were not in equal ratio. Stop. The petitioner was all along issued work order with less quantity of work. Stop. Had the work order been issued at the 50-50 ratio, comma, then the petitioner would have been able to match the figure that is inserted in the inserted as eligibility criteria in the notice inviting e-tender.
Dated 24th February 25.
Dated 24th of February 2025. Next paragraph. Prayer has been made to set aside the words which have been inserted later on. Paragraph. An application for addition of party.
I am pressing application. I am not pressing. Application for addition of party.
An application for addition of party has been filed by one Vishwanath Ghosh. Stop. It appears from records that the said Mr. Vishwanath Ghosh and the writ petitioner Santosh Bhagat were jointly issued the tender for the earlier period, and there was a decision by the additional district magistrate within bracket G for distribution of the work order in equal proportion in between Santosh and Vishwanath. Stop paragraph. According to Vishwanath, he is a necessary party in the instant writ petition, as any order passed herein may affect his right to participate in response to the notice inviting e-tender. Dated 24th of February 2025. Stop paragraph. The learned senior counsel representing the instant writ petitioner Santosh Bhagat in the earlier writ petition filed by Santosh, being WPA 1395 of 2025, appears for the applicant, that is Vishwanath. Stop paragraph. Learned counsel makes it clear that learned counsel for the applicant makes it clear that the earlier round of litigation was only for deletion of the relaxation that was allowed by the authority in the notice inviting e-tender within bracket re-tender dated 7th January 2025, where both Santosh and Vishwanath were the only bidders. Stop. Paragraph. Learned advocate representing the state respondent relies upon the instruction forwarded by the District Program Officer ICDS Murshidabad, signed on 10th March 2025. The same mentions that
Where is the third channel?
the petitioner challenged the first tender notice dated 26 September 2024. And the said tender notice was cancelled by the tender committee as only 2 tenderers participated in that particular tender. Stop. A fresh tender notice was issued with the clause that the registered distributors of food and supplies department may participate in the said tender process without fulfilling the necessary conditions mentioned in the tender notice. The writ petitioner challenged the said tender notice and the petitioner made an objection before the authority. Stop. An authority in authority by virtue of the leave granted by the court. Stop. The authority deleted the relaxation clause relating to registered relating to participation of registered distributors of the food and supplies department. Stop. After deletion of the said clause, the tender committee issued fresh tender notice dated 24th of February 25, and the petitioner has challenged the same by claiming it to be the third call. Stop. Paragraph. The instruction mentions that according to the finance rules, comma, third call is not permitted, as the third call tender notice is liable to be cancelled or modified or modified. Stop. According to the authority, the fresh the tender notice dated 24th February 2025 is not the third call, but it is the continuation of the second tender notice. Stop. Paragraph. Upon hearing all the parties and on perusal of the materials on record, it appears that the first and the that the first tender notice was issued on 26th of September 2024. Stop. The second one was issued on Seventh January 2025. Wherein it has been mentioned as notice inviting e-tender within bracket retender. And the impugned tender notice is dated 24th February 2025, mentioning notice inviting e-tender bracket retender. E-tender bracket retender. The first NIET is numbered 02/NIT/2024-25. The second is numbered e-tender notice 03/NIT/2024/2025. And the last one is numbered e-tender 4/NIT/2024-25. Stop. The submission, not submission, the stand of the authority that the impugned NIET dated 24th February 25 is the continuation of the second tender notice does not appear to be proper. Stop. Assuming that the notice inviting e-tender dated 24th February 2025 is the continuation of the earlier one dated 7th dated January, na? 7th January 2025. The 2025, the authority could not have inserted new terms and conditions. Stop. A condition which was not there in the earlier one. Stop. The moment the authority uses the expression for each year, which was not there in the earlier NIET, the fresh tender notice partakes the character of a new tender and does not appear to be the continuation of the earlier one.
What she has said, for each year, clause should be mentioned. In two spell manner it has been stated. We are interested about clause 7A.
And B. E-tender for each year in clause 7 VII within bracket small a and small b.
Great.
It appears that in the first, it appears that there were 5 bidders in the first tender call, and the bid of all 5 stood rejected at the technical stage. The second tender could not be proceeded as there were only 2 bidders, the writ petitioner and the applicant. And the third tender notice has incorporated a further stringent clause restricting participation. Stop. Paragraph. the memorandum of the finance department, memorandum number 9754-F within bracket Y, dated 3rd December 2012 of the Finance Department Audit Branch, lays down the procedure for retender. Mentions that if the response to tender, including e-tender within quotes, first bracket, is less than 3, then tender should be invited afresh. Such retender notice shall be published widely and circulated in the daily newspaper and also through the e-tender portal. Prior to invitation of retender or fresh tender, the eligibility criteria and other terms and conditions as mentioned in the first, within single quotes, notice inviting tender shall have to be reviewed by the tender inviting authority to ascertain as to whether the terms and conditions are too much restrictive, specifications and qualifications were fixed at higher standard than required. Stop. Even if after taking appropriate steps, the response to retender is less than 3, the tender may be accepted without reference to the finance department, provided the rates do not exceed the estimated or the scheduled rates beyond 5%. In case of works estimate and reasonable prevailing market price for goods and services in other cases. Service in other cases. Otherwise, such cases should be referred to the finance department for decision. Paragraph. It appears that in the instant case, the authority is not being able to get proper bidders in response to the notice inviting e-tender, the tender inviting authority accordingly ought to act strictly in terms of the aforesaid memorandum dated 3rd December 2012. The addition and insertion of the words for each year in clause VII within bracket A and B of the NIET within bracket retender dated 24th of February 2025 cannot be made applicable if the same if
B is not required.
If the notice inviting e-tender dated 24th of February 2025 is to be proceeded with. The writ petition stands disposed of. The as no allegation has been made against the as the order passed herein will not prejudice the the applicant in any manner whatsoever. Accordingly, the application for addition of party stands dismissed.
One word Lordship has given. Clause 7A and B Lordship has said. B should not be there.
Why
Only
it
A.
should not be there?
Because this condition was throughout there.
It was not there. For each year was not there.
Each year 60,000 was each year.
80 lakh was there also.
80 lakh each year was not there.
Each year was not there in B also.
Yes, but, it was there. It was there. It was there. There may be a mistake on my part in not drawing.
Maybe it is a mistake in here also.
Page 44, kindly come. Very clearly it is stated.
Oh, only for each year.
Yes.
And in the earlier one?
Earlier one, no, each year.
Each year was not there.
No.
তাহলে প্রথমেরটাতে নেই।
Yes.
This was there in the 24th of February. 7th January notice inviting tender. This was not there. ঠিক আছে? তাহলে লাস্টে যেটা বললাম না? লাস্টে যেটা বললাম? In clause 7A. Only এটা রাখুন।
Grateful. Lordship has given some time limit for calling the new tender.
Nothing.
As well. Grateful to you. Deeply
For
obliged.
call 7 months.
Service the name. Get.
I am challenging
Yes.
judgment
I am appearing on behalf of the respondent.
passed by the National Green Tribunal.
State Coastal Zone Management.
Or would your lordship take it after the recess?
If you want, it can be taken up.
It is
Take
a very small matter.
Will take some because my
He says it's a small matter. What? Make it simple.
Yes.
Then
May I
not so malord equipped so to bring this matter into a very small point is that the National Green Tribunal has passed an order on the basis of a committee which in turn relies upon another committee which is not there on record. Second point is that the National Green Tribunal, while enforcing the CRZ regulations of 2011 has failed to appreciate that the 2011 map is not available in the website. So no one knows what is the demarcation. Now, this particular malord, there is a
Was similar matters moved before
yes,
this?
Mondarmoni matter
Yes,
is there.
Mandarmoni matter is there.
In Mondarmoni, one of the points is similar. There also it has been said that I have annexed that order also of your lordship that the CRZ MP, that is Coastal Regulation Management Plan, is not available. That submission was made by me before the honorable before the learned National Green Tribunal in this matter, where the National Green Tribunal was pleased to hold that in the previous matter I have not accepted this submission.
So this time also I will not accept.
I will not accept. But the previous time the submission was made by an Article 12 authority who is the person entrusted to for preparation of the matters.
And admitted that this is not there.
They said so, and the tribunal did not agree with them.
All right.
Tribunal said that no, I do not agree. Since it is there, it is supposed to be there and something like that. My lord, on that pretext, your lordship was pleased to my lord grant a stay in the Mondarmoni matter, which is my lord annexed with your lordship. But my lord, in this matter, the additional point is also there that the particular my lord report which has been relied upon has been supplied to us, but that committee report relies upon another report, which is CRZ status report, which is not there on record.
Very well. Do you have a copy? Has this MP, the management plan, been prepared?
Lordship, that I do not have instructions as of now, and state will be the answering respondent.
Who are you representing?
I am representing 11. CRZ.
11.
Yes.
All right. This it's a State Coastal Zone Management Authority. Who is for the state?
So this is
still on legs. It's already recess time.
then
Yes.
it's bar, right? Now, my lord, what I'll be trying your lordship, my lord, I'll be drawing your lordship's kind attention to the tender, and thereafter my selection, and my lord, tender floated by the DSDA, who is the authority for my lord floating tenders. And my lord, what happened, my lord? Here, my lord,
DSDA, who is this DSDA?
DSDA is the, my lord, Town and Country Development Authority, Digha Shankopur Development Authority, formed under the Town and Country Planning Act.
Who is representing?
But in the lower court, my lord, in the my lord, tribunal, Mr. Noyan Bihani had represented.
He also appears before.
He
Maybe
appears-
possibly he represents this authority over here. Where is he?
my lord,
Give him a
we have
call.
served him. We have served him.
Give a call to him also so that he can come.
Or my lord, notice has
And
also been given. If your lordship, my lord, wants, my lord,
HITCO is also there.
yes, HITCO is in respect of not our matter, my lord. What happened, my lord? Mr. Dotto had filed this original application challenging 3 constructions. First is the Jagannath temple, which is HITCO. Second, which is being built by HITCO. Second is my lord Satyajit Ray Memorial, my lord, cafe, which has also been directed to be demolished, which is being done by the state government. And third is our, my lord, which is an amusement, which is a my lord, existing toilet complex, which has been, my lord, developed. Now, my lord, in respect of the first and second, my lord, first, my lord, the Jagannath temple has not been touched, my lord. But the tribunal has said that it is okay, it has clearances. And my lord, the second part is Satyajit Ray, my lord, Memorial Cafe, which has been touched and directed to be demolished, which in respect of which I am not concerned in view of the fact that it is not my facility. Third is in respect of the my lord, Deusagor, which is basically an amusement park, which has been built on the basis on the premises which was there in respect of an existing toilet complex. Now, my lord,
The toilet complex is being dismantled.
toilet complex, what happens, my lord? Toilet complex are not run properly if only given on the lease. So therefore, my lord,
Are you the lessee for the toilet complex also? You are the lessee.
It was basically a garbage area. It was, my lord, developed because of this tender. Now, my lord, what happened in 2000, beautification and all these things. In 2011, my lord, there was no provision for this my lord, toilet complex and development and all these things. In 2019 notification, a provision was made that if it is in CRZ 2, then this toilet complex or something, this has been temporary tourism facilities shall be permissible in the beaches, which shall only include shacks, toilets or washroom, changing rooms, such and such, and it will be in accordance with the CRZ MP, which is not there. In respect of 2019, there is no CRZ MP admitted. Now, my lord, after this, my lord, this DSDA floated a tender on, my lord, 18th January 2000.
Has the original applicant been served?
Yes,
everybody has been served.
Everybody served.
All right.
It is, my lord, it is, my lord, a matter of practice that he doesn't appear, my lord.
Plus,
In the previous matters also, I have moved before a lot.
Pollution Control Board.
My lord,
Pollution Control Board.
Everyone, sir. Everyone. Sir.
Anybody appearing? Pollution Control Board.
PCB. Affordable services also.
National Center for Sustainable Coastal Management.
Yes, yes.
Ministry of Environment, Tamil Nadu.
Yes.
All
have
the national.
That's the national authority, but
Yes.
We have served.
And what is the immediate threat that you are apprehending?
the tribunal has directed demolition of a partial part, which has not been demarcated, of course, within 3 months. This judgment is of 21st January 2025, and these 3 months will expire in 21st of January of 21st of March of this. So therefore, I'll be
3 months, you say?
Yes, January.
January,
April.
February, March, April. So you still have time.
Yes, my lord, but still, my lord.
And serve once more. Let everybody come. Please come.
Status quo may be maintained, my lord.
Why? 3 months time.
But then I have a very good case.
I'll post it next week. Only you serve and come back.
I will, my lord, survey. 2 times notice has been served. Notice of upgradation has also been served.
Yes.
There are
At
3
least put
notices.
them on notice. Let Mr. Bihani or whoever appears for the tender inviting authority come. Let the pollution control board come. He's coming. And then the pollution control board has to come over here. Somebody appears. I do not know. See, Mr. Arjun Roy Mukherjee appears in a lot of matters. I do not know.
They have been served, well, and we have also served notice that this matter was mentioned. Lordship was pleased to upgrade everything. Well,
Very well. Just put them on.
okay.
Yes, Mr. Bihani is here. Are you there in this matter? No. Copy not yet served.
I tell your lordship,
Not given.
most of the time copy served, we do not receive it. My juniors don't receive it in time.
Very well. Then
I have to ascertain, but I am appearing in the
National Green Tribunal.
So the National Green Tribunal will appear on behalf of the Digha Shankar, the authority concerned.
So it's same authorities over here.
Yes.
Take instructions. I'm posting it next week.
Lordship.
All right.
I mean, discover.
Quite a few of the respondents are not represented despite service. Stop. Let further notice be issued. Stop. Relist on 24th. Next Monday. Next Monday. Difficulty.
Tuesday, Wednesday.
Wednesday, 27th.
Wednesday,
No, 27th I am before NGT.
अरे Wednesday 26 पहला date देखना.
वो तो देख रहा है.
अच्छा एक डेट देके पूछो.
क्या देखिए बताइए.
27th then, well.
No, lordship. I have some difficulty on 27th.
28.
27th.
Well, I am
Friday, it's not possible. 27th,
not
calendar town.
Not
26th.
26th, I'm fine.
26th also you are not there.
I am there every day.
No, there. If
keep it at 24. I have a
24th hour
की अच्छी.
Monday, 24th. Mr. Galib also take instructions. Call the next matter, please. And record everybody's appearance. Those who are not appearing. Those who are appearing.
Excellent. 26th is the problem because Monday, I tell you, excellent. Monday, I tell you, lordship, I will be here. Obviously, I don't have a difficult problem. But my lord, knowing that the weekend is there, and knowing, I tell you, lordship, and knowing, my lord, the programs that is going on, my lord, I'm not sure. Kindly keep it on Tuesday. Otherwise, everybody. Oh, Baba, lordship keeps it on Monday. I'll try and take instruction. I cannot ask him not to travel outside.
Grateful, your lordship.
Let it
Yes,
change
8.
position,
Yes, urgent motion.
अरे सुन ना हमारा कॉपी देने जरूरत तो हमारा दुकान में इनको होने का
I have here for respondent number 4.
Official respondents.
Well, I have served upon.
Housing finance.
So I think my learned friend is.
DM state must be here.
State is not there.
I have served upon the DM also.
Did you serve the GP's office?
GP's office? GP's office didn't accept.
Did not accept?
Because this the DM, he appoints personally all that. So he's an authority under the Act.
So what?
But I think my learned friend is the main respondent.
No.
Maybe, but then you have implemented the
But
DM,
I
the
have
officer,
served DM. I
the
have
police
served
officer.
DM person twice. State, unless the state is a party, GP is not accepted. But he is exercising power under the Act, Special Act.
Yes, what is it?
Now, I tell you, losses, kindly come to the loan agreement at page 24. I have to take your losses
24. 24.
Running
Yes.
page 24. That's it. Now, your losses.
What is the stage, please say, without going through all these.
But I tell you, losses, 13 to application, second time issued. And this is covered by the Supreme Court judgment.
It cannot be done.
The moratorium period, they have done it.
They have?
And additional interest. They have issued it during the stay granted by the Honorable Supreme Court. That period, they have declared my account NPA.
Which moratorium period, which was
I tell you,
during?
losses against the moratorium reserve band granted, my lord, up to August. Then certain applications was moved before the Honorable Supreme Court.
Yes.
Similar on the assurance of the Solicitor General, the Supreme Court state.
Moratorium for what? IBC?
I just give you a loss.
Is it bankruptcy?
Moratorium for my lord, COVID.
Bankruptcy, COVID period.
COVID
period.
Oh, COVID period.
Now, my lord,
All right.
Yes, now, kindly allow me.
There are many types of moratorium. So
I
yours
just-
is COVID.
COVID.
All right.
Now your losses kindly come to my lord, page 24. I have to take certain documents, your losses. Now your losses will find tenure 100 to
No, after 13 to what happened?
Malad, that application is pending 34, and then Malad they have issued Malad that's pending before the date. In the meantime, they have moved the Malad the district
DM's
magistrate
office.
and the order has
Section
been passed.
14.
Malad ex facie bad in law is both the orders. I tell you, Lordship, how they are
And what
proceeding.
about your proceeding before DRT?
That's, my Lord, I'm praying
There
before
is
your
no
Lordship that,
interim order, my lord.
my Lord, 2 ways, this pending. Your Lordship,
Yes.
give me a breathing time till such time they do not take. This is a nursing home.
But petition is not maintainable.
Wait, please
This is a,
wait.
my Lord, the point.
Yes.
Now, Your Lordship, I have more than 100 patients in the hospital,
All
or
right.
in nursing home. Now, my Lord, I have filed, my Lord, the foreclosure notice also. They didn't. My Lord, they declared my earlier notice 13-2, declare my Lord, account NPA before the 90 days period fixed by the RBI. Then I moved before the my Lord, DRT. As soon as I moved it, taking on the grounds, they withdraw the notification 32. Issued fresh notification declaring my Lord, the NPA account again 21st. Now then consider your losses from 2020 to 21st. They illegally declared my account NPA. I could not do anything. Now they are charging additional interest, penal interest, everything.
When is your next date before DRT?
Lord, if your losses, my Lord, I have to mention it and get it done.
A date has been fixed.
Lord, I can't tell you losses the exact date.
Why? The date is there. It's uploaded
Lord,
to
the
the server.
earlier I tell you, Lossi, the earlier application pending, they have taken thrice the grounds for filing affidavit. Even then, the second application is now pending. Now you lost.
And where is the order under section 14?
Malad, that's your losses, page 98. Lord, may I take your losses the 13-2? That should
No, nothing now. Wait. This is dated 4th of February
4th of February
2025.
2025. Kindly see your losses, then page 98, clause 2. Clause 2, page 98. The borrower has committed default in payment of financial assistance granted aggregating the specified amount and consequent to such default payment, the account of borrower has been classified NPA on 10th January 2021 due to non-servicing of interest or installment. Give me the Supreme Court judgment. Supreme, kindly see the order of interim order. Judgment. Kindly have a look at this order of the Honorable Supreme Court. Then I will show to your lordships the final order. It is reported by copy. Now, kindly, your lordships, the third page. At the request of Mr. Tushar Mehta, learned Solicitor General, the matter is adjourned for 10th September 2020. Mr. Harish Salve, learned Senior, submitted no account shall become NPA at least for a period of 2 months. In view of the above, the accounts which were not declared NPA till 31st August 2020 shall not be declared NPA. Kindly see. Even then, they declared NPA. Now, your losses kindly
next
see the
order. Next order.
Your losses kindly have a look. This is reported in copy. This is reported in Malad 2021 volume 8 SCC page 511. This is an order of March 23rd, 2021. This interim order was passed by your lordships on the September 3rd, 2020. This interim order was disposed of in this by this order. Your lordships kindly consider page paragraph. I give you losses the paragraph only. 100. Just 101 to paragraph. Page ta koto bolo to. Just I give you losses. Page 101. A paragraph 101.
Yes, paragraph 101.
Even otherwise, it is required to be noted that the compound interest on interest shall be chargeable on deliberate and willful default by the borrower to pay installment due and payable. Therefore, it is in the same nature of penal interest. By notification dated 27th March 2020, the government has provided deferment of installment due and payable during the moratorium period. Once the payment of installment is deferred, as per circular dated 27th March 2020, non-payment of the installment during the moratorium period cannot be said to be willful, and therefore there is no justification to charge the interest on interest or compound interest or penal interest for the period during the moratorium. Therefore, we are of the opinion that there shall not be any
This is regarding penal interest.
penal interest. Then your losses kindly see 103.
Yes.
Therefore, your losses kindly consider by this order, this page 102, connected, all the applications are disposed of. That waiver, all these. Therefore, interim order was valid till this date of judgment.
March 21.
My account was declared NPA on 10th January 2021 during the validity period of the interim order. And kindly see now, Malad. And kindly see, Malad, 103. However, it is directed that there shall not be any charge of interest on interest, compound interest, penal interest for the period during the moratorium, and any amount already recovered under the same head, namely interest, penal interest, compound interest, shall be refunded to the borrowers concerned and to be given credit and adjustment in the next installment of the loan account. All these petitions are partly allowed to the aforesaid extent only and as observed for the reliefs, and the petitions are dismissed. Interim relief granted earlier not to declare the accounts of as NPA stands vacated. So, till that March 2021, they could not have. Now, what they have done, your lordships, apart from section 14 notification, your lordships kindly consider this. Page 66. The second notification under 13.2. When it starts at page 66, that my lord, kindly take note of this. 17th November 2023, 7 November. Then your lordship, page 67. Kindly see in the bold letter, nota bene, earlier demand notice dated 7th May 21st stands withdrawn. Then you'll see last paragraph. Hence, the loan account has been classified as non-performance account with effect from 1st January 2021. Now, this is itself bad.
Which portion are you reading?
Page 67, last paragraph.
Last paragraph.
Have committed defaults on loan. The loan last payment, my lord, 10th February 2020, just before the my lord, commencement of the pandemic. So I had not committed any default. Hence, the loan account has been classified as non-performing account 10th January 2021. Kindly see it comes within the clutches of the Supreme Court order of stay. And then your losses kindly come to page 68.
Yes.
Kindly see the additional interest.
Additional interest and everything, all points are open there.
Every demand is wrong.
These are open over there. Immediate relief is section 14 application has been allowed and that is required. That is
that I should be given some breathing time so that my application before the DRT should be heard. And it's running my lord, nursing home.
Yes.
As per the RBI guidelines, my lord, on this moratorium, my lord, this is applicable only for the running accounts. They are defaulter prior to my lord COVID. And my lord, as of today, my lord, the outstanding.
But then you declare the petitioner as defaulter NPA on 10th of January 21.
Yes, ma'am.
Page 98.
Yes, ma'am.
And then again, on 10th of, oh, it's the same date, 10th of January 21. This falls within the Supreme Court judgment.
Could I, my lord, look up the law once and come back tomorrow in the morning, my lord? Since you have urged, taken a point of law, my lord.
Yes.
Could I, my lord, look up the law once and come back to assist your lordship, my lord?
When, any idea about when the order of the DM to be executed?
Police every day is knocking at the door. Running the nursing home, my lord.
Let me come back tomorrow. But till tomorrow, there will be nothing, my lord. They will take no steps.
No, but then tomorrow is too early. You cannot say today the matter is taken up. Again, tomorrow it will be taken up. Then the court will remain held up in only one matter. There are other matters also. When was this order passed?
In the month of February.
4th of February 25. Right. Are you aware when the next date before the tribunal is fixed? The order must be
has
there.
not been uploaded.
11th March.
When was it taken up?
11th March.
11th of March. Well, today is 17th.
There was a direction to file, my lord, affidavit, my lord, before the.
And you failed?
No, my lord. On that day, direction was given.
First day?
Yes, ma'am.
It has been submitted that you have.
Well, that's earlier application because the earlier notice
There are, my
was
lord,
withdrawn.
2 section 17 applications pending.
Section
Yes.
17.
One is of
That's become
2024.
infructuous earlier one because you have withdrawn.
After
We have withdrawn page 68.
you've withdrawn that?
Yes, yes.
They have withdrawn the earlier notice.
That's,
So it
that's why my
becomes-
application also goes.
First one is infructuous.
It has become infructuous. Very well. Please come. The petitioner is aggrieved by the steps taken by the respondent number 4 in approaching the district magistrate under Section 14 of the SARFAESI Act. Stop. The order of the district magistrate dated 4th February 2025 is impugned herein. Stop. The same records that the borrower committed default in repayment of the financial assistance, and the account of the borrower was classified as non-performing asset on 10th January 21 due to non-servicing of interest/installment. The district magistrate, upon satisfaction, passed order for taking physical possession of the secured asset within a period of 6 months from the date of receipt of the order. Stop. Next. The securitization application filed by the petitioner before the Debts Recovery Tribunal declaring the account as NPA and the steps taken by the respondent number 4 for recovery of the secured amount is pending consideration. Stop. Paragraph. The order passed by the Honorable Supreme Court in the matter of Gajendra Sharma versus Union of India and another. Order date. The order passed by the Honorable Supreme Court on 3rd September 2020 in Gajendra Sharma and another has been placed, reported in 2020 SCC online SC 1240 has been placed, wherefrom it appears that the Honorable Court was pleased to direct that the accounts which were not declared NPA till 31st August 2020 shall not be declared NPA till further orders. Stop. The said matters to disposed of by the Honorable Supreme Court on 23rd March 2021. By passing necessary order. The in the instant case, it appears that the account of the petitioner was classified as NPA on 10th January 2021. That is the period during which the order passed by the Supreme Court in the matter of Gajendra Sharma within bracket Supra was subsisting. Etar reporting ta likhe nin to 23 March 21 reported in 2021 8 SCC 511 within bracket Small Scale Industrial Manufacturers Association within bracket registered versus Union of India and others. কি বললাম?
During which the order passed by the Honorable Supreme Court in the matter of Gajendra Supra was subsisting.
Stop. The district magistrate possibly was not made aware of the order passed by the Honorable Supreme Court, and accordingly, the DM went on to pass the order for taking physical possession of the secured asset relying on the declaration of NPA by the respondent number 4. Stop. The fact as to whether the respondent number 4 could have declared the petitioner's account as NPA on the subject date is pending consideration before the Debts Recovery Tribunal in the securitization application filed by the petitioner. Stop. The said application is likely to be taken up for consideration by the tribunal shortly. Stop. In view of the above, the respondent number 4 there 6 months time has been granted. 6 months time have been granted by the district magistrate to execute the order passed under section 14 of the SURFACE Act. Stop paragraph. In view of the above, the respondent number 4 is restrained from taking steps to implement the order passed by the district magistrate on 4th February 2025 till 16th of May 2025 or until further order, whichever is earlier. Stop. The petitioner is granted liberty to approach the Debts Recovery Tribunal by filing appropriate application by bringing the to bring the order passed by the district magistrate on 4th February 2025 on record, seeking necessary relief. The writ petition stands disposed of.
Kindly record my submission that the writ petition is not maintainable. my lord.
Why? You have to say why. Only recording will not do for the
Not because,
reason.
The remedy is available before the learned DRT, my lord, and DRT is functioning, my lord.
Yes,
Remedy
this
lies
is exactly the same
section
thing.
17, my lord.
Very well. Act a line লিখে দিন তো, learned advocate representing the respondent number 4 submits that the instant writ petition is liable to be dismissed as alternative remedy is available to the petitioner. Stop. The application filed by the petitioner is pending consideration before the DRT, which is functional. ঠিক আছে? One minute. Item 9 also. Please call.
My son, my lord, was having an excise license. But he was operating, my lord, the shop. My lord, unfortunately, he died. My lord, it is in respect of a property which is, my lord, owned by me and my brothers. The shop room which is situated over there.
You and your brothers?
Yes, the ownership is with myself and with my two brothers. Joint
Right.
owners. Wherein, my lord, in consent of
Inherited property?
no. Purchased property. I have annexed the purchase.
You with your two brothers purchased the property.
Lord, ultimately, we allowed both my brother or as well as me. Lord, we allowed Lord, my son to proceed with Lord, that business. Lord, the license was Lord, if your lordship takes up page 23.
Yes.
Lord, I shall take your lordship. Why Lord, I am drawing this analogy. Lord, kindly takes up Lord, the name of the district is such and such. Lord, the column. Second column, name of the licensee. Has your lordship got it? Amit Shah. So license is in the individual name of my son. Because immediately on the next preceding column, your lordship will get persons holding license in case of firm, company and society. The right hand column, it is empty. So my son was not having Milord this license on behalf of any firm or Milord any company or society. So it's in his individual name. And name and style of the shop is Messrs. Amit Shah FL on shop. So this was my son unfortunately died. Lord, after the death of my son, Lord, I made an application, Lord, page 41 of my lord's brief, because the widow, Lord, my daughter-in-law, she also applied. Lord, I have Lord, made Lord, this application, page 41, But I have stated 42 from
Now
both.
it is the fight between the mother-in-law and the daughter-in-law.
Yes,
Not wherein, but I have stated that
So
even
there is a provision to apply before the DM
that I am coming
for
from the previous round of litigation, that I approach
Passed an order pursuant to this or.
and that's an
Ah.
applicable order also.
yes, and why to enter here?
but I am coming to this. But kindly see, my lord, the last order of the coordinate bench where, my lord, I approach this honorable court. My lord, page 44 of my lord's.
Yes, yes. Right.
But I am not on, my lord, this order right now. The question in this writ petition, my lord, your lordship will get 14.6, my lord, the grant of license. The petitioner claim, my lord, from the second paragraph of the first page. The petitioner
All right,
claims-
the last portion, page 46, the DM was directed
No,
to
not
treat
only
the
that, my lord,
petitioner
kindly
different
takes up
for the
page 2
same.
once. Page 2 of the, my lord, coordinate bench order on the earlier round. My lord, it has been decided, my lord, in respect of the submission made by Mr. Basu Mollik with regard to, my lord, 14.6, whether it can be granted in the joint name, because both of us is the class 1 heirs, according to the Hindu Succession Act. My lord, this honorable court decided there is no bar. It can be more than one person.
Nothing has been decided.
Yes.
My lord, this has been, the provision is being quoted. Kindly turns over the page. Page 3. Usually when there was more than one legal heir and no objection in the form of an affidavit is obtained from the other heirs before issuing the license in the name of the one of the heirs of the deceased, the rule relied upon do not indicate that the license can be issued only in respect of one person. So my learned friend cannot say this issue remains res integra. This has been decided. They have preferred one review application, did not move that. This, my lord, I shall show before your lordship. Thereafter, my lord, ultimately, direction was passed to take a call in.
Where is the order of the DM?
My lord, I am coming. So, my lord, this honorable court directed, my lord, that application to be disposed of. Kindly takes up, my lord, now the order, page 50 of my lord's brief.
21st of February.
My lord, the district magistrate decided that the provisional license.
Yes.
I shall take your lordship some of the operating portion. My lord, my husband, since do have a 7,000 rupees, my lord, income from his, my lord, working in another, my lord, shop room was being considered, and my lord, my husband's, my lord, land, though it is not as specified in the, my lord, order, do not have, my lord, my husband do not have, my lord, that quantum of land. As Borgadar, my lord, there are certain quantum of land. On the basis of this,
what does the widow do?
Nothing. That has been recorded.
11th month son, my lord.
Huh?
Having 11th month son, my lord. With her.
6 months.
What will the widow do if the mother-in-law is
I
trying?
am coming, my lord. It's not that I have categorically stated I am ready to bear every maintenance towards my. My lord,
1 minute. Let the daughter-in-law run it, and her family. She has 11-month-old child.
I am taking, my lord, your lordship. Not,
This is an appealable order. Please go.
my lord, it's
I'm not
my lord,
interfering.
I am not on that even. My lord, my lord, she is having, my lord, her father is a reputed police. My lord, he does have, my lord, that quantum of in Navarno. He is sitting. He is making everything.
You do not have a proper relationship with your daughter-in-law.
Lord, I don't. Lord, I leave it to your lordship. We can run both together.
No, you cannot. You cannot run. Every day this problem will arise. There will be tussle between the mother-in-law and the father.
That's why I am ready to bear every maintenance.
No.
On the contrary.
No question of bearing maintenance.
Lord, kindly consider what is the order impugned before your lordship.
Nothing.
The district magistrate did
Show
not
the
even.
provision for appeal.
Lord, I am coming. Lord, kindly bear.
No, sorry.
For a minute, Lord.
Not at all.
The district magistrate has not even considered.
Oh, this book is
Yes,
here.
yes. My page 397.
Janabu?
The district magistrate did not even consider the grant of final license. I shall rely upon the rules below. My learned friend, the provisional license is for a particular period. After
the shop room also.
It's over my property.
397 money.
The moment you say it's over your property, it's very much makes
Whether
it clear that
whether
there
the
is a
mother
very-
don't have any right. The daughter-in-law
Mother
will
may
run
have
it.
Mother may have
That
a
is-
right. Nobody is saying you do not
But
have a
I
right.
don't
But
have-
when the relationship is so much acrimonious, you are throwing out your daughter-in-law
It's
from
not
there.
about that. Milord, she by her own, Milord, she has disowned.
Very
She
well.
has gone to his father's, Milord, property. Milord, her father is renowned, Milord, officer. He is sitting
Whoever
at
it
Novanno.
is,
Milord, she does
the
have
court is not
everything.
concerned
But
who
I
is
am not.
renowned.
I am agitating with regard to my
Nothing.
legal right. Kindly consider, Milord. The learned district magistrate has not even
There
decided
is
with
no
regard to the
legality to
permanent
temporary
license. He has said whatever the provisional license, that is correct. But that was not the tenor of the order passed by this honorable court. Milord, the mandate of the rule says it has to be decided Blood, if one of them is blood taking that, blood, another no objection is mandatory.
Page 397, you said?
Yes, my 396, my lord. An appeal,
396.
an appeal
Lie to the collector
excise commissioner from an original
from the order
or
of an
appellate
officer
order made. B, thereafter, my lord, after excise commissioner, thereafter an appeal shall lie to the secretary. Oh.
Lord, I am not challenging that part. Lord, what I say, Lord, my application for Lord grant of Lord final license has not even considered by the district magistrate. Lord, the district magistrate said whatever the provisional license that was being granted, correctly granted. Lord, that was not the ground. My application is for grant of final license. They will have to settle. The law suggests they will have to settle it once for or the other.
Please come.
One thing
Did you file your wakalatnama?
in course of tomorrow, my lord, I have
Why did you not mention?
received 2 days.
You should file it, or you should tell the court that yes, I am holding it, I can file it. Acha, una namta likhe din, appears for the private respondent.
My lord, only thing, my lord.
And submits that.
My lord, only thing they have to
Wakalatnama.
settle the dispute because the only one legal year can. My lord,
Shortcut. The wakalatnama has to be filed. No, wakalatnama will be filed in the department in the course of the day.
Lord, this can be done with your lordship's intervention. Lord, I am saying.
What were you submitting?
But I was submitting, my lord, I am saying as per the 2023 rules, only one legal year can succeed.
That's why, my lord, this can be sought out
with
your lordship's intervention.
My lord, they should settle this between
My client has taken.
Or else the alternative is we have to withdraw the license. That is
that's why, my lord,
the mother-in-law wants that also.
Lord, no, I am not saying that.
Go to this
Let her
extent.
run. Let her, Lord, give at least some quantum as maintenance to my client.
Yes.
At
Have you
least,
followed?
Your lordship.
Where it is going to? I understood.
I am entitled to that under the law. Lord, under the law, I am entitled.
It
Let
can
her
never
run.
be settled.
Lord, let her run. Let me give. Lord, if I will be allowed to run, I shall provide him maintenance. If he is
belongs to them, they are not shops key room.
Shops?
For a liquor shops key room, key has
Key.
been, yes, they have taken away.
The keys have been taken away.
Provisional license has been granted me. I could not able to open my shop room.
Yes. Will you be able to run it?
Yes, my lord.
Sure.
Let her run. Let me provide maintenance, at least that much of security. Lord, I am ready. Both of instruction I have taken.
For betterment of a child. And what about the mother?
That portion can be decided by the authority. My lord.
Which portion?
No, how can I decide?
Which portion will be decided?
Already passed an order. My lord, the provisional license has been granted to me. That is, my lord, correctly done.
I will suspend by 7,000 of my husband's salary.
Under 37, section 37, it is only for 6 months.
6 months lapsed. That's why, Lord, your lordship intervenes. I have taken that instruction also. Let her run. At least provide me something so that I can sustain. After all, it's my son who died.
Her husband who died.
Yes, also, my lord, I only.
So you it's not a matter of appreciation.
I can.
This cannot be done.
That's yes, checks and balance. But I bow down before your lordship. That's why I say let her run. At least provide me something.
You will throw her out of the house.
No, my lord, kindly take instruction. I can make myself, my lord, my client shall be present. It's about her own choice. She left the matrimonial home.
Why did you leave the matrimonial house?
They have driven out.
Milord, I am ready, Milord, today itself.
And will the lady stay in the matrimonial house if the mother-in-law does not stand in the way?
They are torturing.
They are torturing.
That is the real, my lord.
Complaints lodged? 498A?
Nothing.
My lord, at present, my lord, 2024, my lord,
husband died, 24.
My lord, son, I have to look after, my lord. I am staying in my parental house, my lord.
Why parental house? Stay in the matrimonial house?
They are not, they are resisting.
Today itself.
What does the mother-in-law do? Does she do anything?
No.
And what does your client do? Where from is she getting the money? Who is maintaining her now?
My parents.
Yes.
Your parents. Very influential ones.
No,
very.
No. That is, my lord, bold allegation, my lord.
Absolutely bold allegation.
I can show before your lordship the sticker in the car. আমি বলতে চাই না দাদা, বলছে তাই।
Let them settle the dispute.
That's why.
This cannot be settled. Mr. Chakraborty,
Or else we have to withdraw, but the rule says we have to
from
withdraw.
the years of practice in the bar,
in both of
we
the
know
terms,
that there are certain disputes which can never be settled.
give certain efforts.
When
both of the way my client
initial
is
submission came, it was of different type. Now the court is going to pass order. Now maintenance issue comes.
No, my lord,
I
in
know
both
what
of
is
the way
going
have
on.
Let me send to the mediation.
both of
Well,
the
let
way,
them, because or else we have to withdraw. The license goes for both of them. But they will not get anything. The rule says not settled within 6 months.
even outside the court,
It is a dog in the manger policy.
my lord, even outside the court, I am telling before your lordship, in the
No,
earlier
you
round
are
of
in court,
litigation,
not outside the
no, my
court.
lord, in the earlier round, I approached my learned friend saying that both of us will lose it. There will be nothing. My lord, the rule suggests in 2023, if it doesn't going to.
What do you want? The license to be withdrawn?
My lord, then I have to take instructions from my client.
Settle kore na.
But in 3 of the way, my lord, I am agreeable.
At all, my lord, desire, my lord, I have to take instructions.
Do you have the books of accounts? Who has the books of accounts?
Sir, it was run at last by my son itself. When
Where
all
are
of
the
us
books of accounts?
Order says
How much is the
petitioner's husband is looking after the shop. Petitioner, the mom and the father was looking after the shop.
Very
That
well.
is recorded.
Very
I can
if
produce
that
the
be
books of
so,
accounts.
don't produce it
also.
before me. You see as to what is the
Yes, I understood.
usual earnings,
Yes.
so that some
that
settlement can be
arrived at. But
Outside the excise law, because excise law doesn't permit.
No. This
certainly
entire exercise
outside.
Also hold, my lord.
আরে তোমার ওটা 6 মাসের জন্য দাদা, ওটা 6 মাসের জন্য, ওর বাইরে
If you get this breathing time of 6 months and thereafter you starve, it is up to you. You will lose the house. You've already lost it. And now this business also will go. It is up to you to decide. It is up to you to convince your client to come to a settlement. At times it is required. And your role is very important over here. Do you get it? This is not the end all of everything. There are litigations coming in future. So it is for you to decide.
I will take it.
The order dated. আচ্ছা হ্যাঁ ওকালাতনামা থাকবে, আজকে না দিয়ে কালকে দেবে, by tomorrow করে দিন, in course of tomorrow. The order dated 21st February 2025 passed by the District Magistrate, HON'BLE, under the provisions of the West Bengal Excise (bracket open) transfer of license (bracket close) rules, 2023. Read with section 37 within bracket small c of the Bengal Excise Act, 1909 is impugned in the instant writ petition. Stop paragraph. Upon hearing the parties and on perusal of the documents annexed to the writ petition, it appears that the son of the petitioner was a licensee in respect of a foreign liquor on shop. Stop. The license is valid till 31st of March 2025. Stop. The licensee expired on when?
5th of August 2024.
5th August 2024. Stop. Currently, there is a tussle between the mother and the wife of the licensee with regard to the holding the license, not holding, transfer of license in their name. Stop. None is agreeable to get the license issued in the name of the other. Stop. Both wants the license to be issued in her individual name. Stop. Paragraph. the license has been issued in favor of the widow of the deceased on provisional basis. Stop. Application made by the petitioner seeking transfer of license is pending consideration.
Restriction.
Stop paragraph. The upon hearing the matter for some time, comma, learned advocates representing the petitioner and the private respondent. Now, petitioner when a private respondent seeks time to take instruction as to whether there can be any possibility of a settlement between the two parties. Stop paragraph. To allow the private respondent to allow the learned advocate representing the private respondent to obtain proper instruction, comma, release the matter on 8th of April.
Grateful.
Service is taken on record.
Provisional license was valid up to 28 February 2020.
It was valid up to February. 6 months has expired. Has it been extended? Are you aware? Then the shop must be closed.
The shop after
আচ্ছা একটা জিনিস একটা লাইন লিখে দিন তো provisional license issued in favor of the widow of the deceased was valid till 28th of February 2025. All the last matter.
Another petition.
Service is taken on record. 10.
Total house building loan 6,50,000.
You are for the bank?
May I cut the matter short?
Yes.
Two parts.
Yes.
First is legal, second is sympathetic.
All right.
Legal, probably he doesn't have a case. Section 14 order issued, police cost submitted, everything done before DRT, and also he is asking
Before
for
DRT? OA was there or SA?
No, nothing there. He can approach DRT. Nothing is
As on now, there is nothing.
There is nothing. And with regard to his main claim, he wants OTS. Even then, your lordship may not intervene. But with regard to sympathetic approach, we, the bank, has already written to him. He made a recent prayer for OTS, thereafter improved. We have rejected both and said that we are ready to take a sympathetic approach. But he has to match.
You are rejecting the prayer for OTS again. Even then, you will take sympathetic approach
because the loan amount is only 3.25 lakhs. 3.25, it was NPA in 2009, right? In 2009.
With interest, it has gone up.
Has now gone up.
NPA 5 lakhs.
Yes, NPA figure is around 5 lakhs.
5 lakhs already offered.
He has
NPA total 5 lakhs 12,000. I offered 5 lakhs.
The only constraint we have,
75%
the only constraint we have is the mortgage which is presently with us is valued at 17.
17 lakh.
Yes. Our policy doesn't approve us to come down below that, since we have a credible security. That is why we are requesting him to come to a substantial figure in OTS so that we can also explain to our higher
What do I do? I adjourn it or I dispose it off?
Well, kindly direct us to take a sympathetic approach. But beyond that, probably your lordship will not intervene.
Certainly not.
Direct us. I do not think.
If you want to quote a figure, let the
that
petitioner
probably
know.
will not be possible.
Then what is the use? He'll come again, isn't it? Because he has not he. Two of them are there. If
Probably
the offer
husband,
is
wife.
5,
No, mother 80 years old. Father already died. But he is a 75% disabled. Parkinson start 2010. Then
we are
for the liquidating the loan amount. All these things hardly matter. Try to understand. So you have to quote a reasonable figure. Otherwise, your property will go.
5 lakhs outstanding.
5 lakhs is the
12,000.
book
I
dues.
offered 5 lakhs.
5 lakhs is the book dues, interest and others. It comes to around 13 lakhs, but the
Yes.
property is 17.
No, property is 17 already. That does not mean you'll go and dispose of the
Yes,
property.
we have said,
Right.
we have said that we are taking a sympathetic approach, but
Acha, ashun to.
kindly do not stay. But we will try to.
The petitioners are defaulting borrowers. Stop. The bank is taking steps to recover the due amount. Stop. The one-time settlement proposal made by the petitioners has not been proposals likhun have not been accepted by the bank.
One prior to writ petition, one after the writ petition.
Even after writ petition. Acha. Paragraph. The learned advocate for the petitioner submits that the petitioner number 2 is nearly 80 years of age and the petitioner number 1 is a disabled person. And it will not be possible for the petitioners to pay off the due amount immediately. Stop. Some time has been sought for from the bank for clearing of the due amount. Stop. Paragraph. Learned advocate representing the bank submits that the loan account was declared as non-performing asset way back in 2009.
2009 though.
Date like kindly see the communication of the bank.
What is it? Give me the date.
There is no date mentioned in the communication.
Yes,
Acha, long.
30/11/2009.
2009. ঠিক আছে
5,12,000.
You have given only 250.
250 ballot
250 is the
total amount 5 lakhs.
250 is the upfront amount.
I mean, that's bona fide for my bona fide.
Yes.
250.
Only not that you have paid 5 lakh or
No, no,
something.
250 ballot is offered.
Offer is
Offered 5 lakhs, 250 ballot on account.
Acha. As per the communication made by the bank on 13th of March 2025.
This is the last one, which was after the writ petition.
Hmm.
First one, there was no signature in the OTS proposal, so we had
So
rejected
whatever.
at the
The total outstanding dues in the accounts in the loan account is rupees 5,12,095. And the total contractual due as on date is 12,98,756,64. Stop. The petitioner offered an upfront amount of rupees 2,50,000. Stop. An order under Section 14 of the SURFACE Act has been passed by the DM.
Yes.
By the district magistrate. And
DM 24
the
Pargana South.
bank is taking steps to execute the same. Stop. Next. As it appears that the borrowers are suffering from both the borrowers are suffering from various medical ailments and the NPA amount is rupees 5 lakh and odd. The bank is requested to take a sympathetic approach to recover the due amount. Stop. Paragraph. The petitioners are directed to cooperate with the bank and try to arrive at a solution. Stop. The writ petition stands disposed of. Service is taken on record.
Till such decision not to.
Actually, the bank is directed to take a call in the matter at the earliest, but positively within a period of 30 days from the date of communication of this order.
It will not.
Stop.
7 days.
At the earliest, positively 30 days. Till a decision is taken by the bank. Comma. The order under section 14 of the SARFAESI Act may not be executed.
By default.
Mentioning that may I have you
mentioning
not for leave on a circuit bench, but without your lordship slip, I cannot file it. That's the whole difficulty.
Why circuit is not
No.
continuing? Next Monday, possibly circuit
No,
will be there.
after 24th.
24th is next Monday.
Yes.
24th is next Monday.
ma'am.
Next Monday you go.
Construction is being carried out
By?
of crematorium without obtaining my license from the pollution control board.
It can be steps can be taken 24th, not so urgent.
Let it be
No,
filed.
no, I can file will go. This will be create problem. 24th you can get it done over there.
19, my lord, for the petitioner.
Yes.
My lord, on the last occasion, my lord, your lordship was pleased to direct me that I should serve a notice upon the private opposite party once again. My lord, this is a matter regarding SC/ST Act. My lord, what has happened? It's a purely, my lord, landlord-tenant dispute. My lord, what has happened? My lord, to oust me, my lord, I am overstaying. My lord, that I admit. My lord, to oust.
You are for the petitioner?
Yes, I'm for the petitioner.
Yes.
My lord, to oust me, my lord, the private respondent has taken a very cunning way. My lord, what?
Wait, let me see the report of the state.
Or I am private respondent. I have a caste certificate, my lord. I have a caste certificates. I belong to ST community. I am a Hindu. And all deeds.
You are a Hindu?
No, I am a private respondent.
Huh? You are?
Private respondent.
Yes, yes. You are scheduled caste?
Yes, my lord. And my deeds, everywhere I am Hindu, not belongs to Sikh community.
You do not belong to the
Sikh community.
Sikh community. You are a Hindu.
Hindu.
All right.
But their pleading says that I belongs to Sikh community. It is their case.
What is your name?
My lord, let me place the facts, my lord.
No, don't place. Where is the state? Sanjeet Singh.
Sanjeet Singh.
All right. Where is the state?
আগের দিনে যে নাম বলছি সেগুলো আগের দিনের নাম
Please intimate Mr. Yusuf is there. Saurav Chaudhary is there for the state. Give a phone call and come back. I'm passing it over for the time being. Yes.
Hello, item number 20, my lord. Mr. Siddharth Banerjee appearing for the petition, my lord.
Yes.
Due to personal difficulty, my lord, he could not come today. My lord, I'm praying for not today.
Only not today? Last occasion also, I see there was an accommodation sought for. 2023 matter. Who are you representing?
Dr. Ms. Pawana Rao Choudhury appearing on behalf of the Punjab National Bank. I am led by Ms. Rao Choudhury.
You are?
Punjab National Bank. Lord.
Yes.
I am led by Ms. Rao Choudhury. She is engaged in courtroom number 29. Lord.
Yes. What is the matter? Are you aware? Are you the on record?
No.
Where is the advocate on record?
My lord, he also could not come, my lord.
Nobody could come. What is the use of keeping the matter then?
Tomorrow, my lord.
2023 matter?
Lordship, I appear for the bank, your lordship.
What is the matter about?
My lord, they have challenged the declaration of NPA, your lordship. Now the bank has went a stage ahead. My lord, 13 to 13.4, my lord, everything has been done. My lord, they are saying the NPA is bad because, my lord, the loan has to be restructured.
13.4, what steps did you take?
My lord, the property, my lord, has been put up on sale also, your lordship. The property, whether it is sold or not, my lord,
That you do not know.
That I do not know.
All right, please come.
And my lord, they have not even approached the DRT also.
The learned advocate representing the petitioner seeks adjournment. Stop. Learned advocate representing the bank submits that the secured asset has already been put up for sale. Stop. Paragraph. When can you come back with instruction?
1 week.
Released on 24th March. Stop. Learned advocate representing the bank shall produce written instruction with regard to the status of the loan account and the secured asset.
Great. Lordship, in item number 21, I appear for the petitioner. Mr. Dhruvo Ghosh is leading me in the matter, your lordship. On the last occasion, your lordship had directed us to serve a notice upon the non-appearing respondents.
I believe the notice has been served, although my advocate on record is not here. Your Lordship will keep it on any other day?
No, madam. This is a 2023 matter. If the petitioner is not interested to proceed, I'm going to dismiss
We
it
are
here and now.
interested to
Then
proceed.
please place it.
Your Lordship, then the respondents haven't filed an any affidavit, Your Lordship, although this appears as an adjourned motion. Your Lordship will keep it for hearing on.
Why? I'll hear it now only. What is it?
Your Lordship, this is a writ petition challenging 2 orders passed by the National Green Tribunal, Your Lordship.
Yes.
Your Lordship will keep it on any other day. Mr. Dhruv Ghosh, who's appearing, will appear, Your Lordship.
How is Zenitco coming over here?
Your Lordship,
how is Zenitco involved?
The petitioner had challenged a forest clearance and an environment clearance passed by the ministry before the National Green Tribunal. The matter was fixed for filing of affidavits on the day. It was.
Yes.
Matter was disposed of on that day by the special bench and not the eastern bench, Your Lordship. Which is why we challenge both the orders.
Who are you representing?
Petitioner, Lordship.
Petitioner? What is your name?
Ishita Ghosh, I am appearing on behalf of Mr. HON'BLE. Kindly give me a short. Oh, good.
She is also appearing for petitioner. You are also appearing for petitioner.
On records, junior.
You are the advocate on record?
No, my senior is.
Your senior is the advocate on record. Yes.
My senior is briefed in the matter, Your Lordship.
Any affidavit of service? Can you show? Is this the manner in which the instructions are to be taken and how a matter has to be proceeded in the High Court?
Your Lordship will give me a short passover. I'll take instructions and come back, Your Lordship. Since the advocate on record was not here, I was appearing, Your Lordship. My senior is briefed in the matter. I'll take instructions and come back, Your Lordship. Will give me a short passover.
Things are not so easy. The matter is pending from 2023. And it was filed in June 23.
Yes,
not a single date I see there is any appearance from the petitioner, and all the time the matter was adjourned or at the instance of the petitioner.
The petitioner appeared on both the occasions, Your Lordship. When
the order sheets are there in the server, possibly. Please check up. I am seeing the records and then only I am making this type of comment. All the time, accommodation on behalf of the petitioner. I do not think the petitioner is interested to proceed, so I'm going to dismiss the writ petition.
Your Lordship.
I'm passing it over for the time being.
Your Lordship will come back with instructions.
Call the next one.
This is my application, my lord. My lord, the petitioner society is the defendant in a title suit, my lord, which is pending before the first.
Who is the other side?
The district judge, Alipur.
How have you served? Under which act is the proceeding initiated?
My lord, I am the defendant in the suit, my lord.
Who is the plaintiff?
The plaintiff is a erstwhile member of the society who had filed the suit.
And you will not make that member a party?
My lord, I had applied for certified copies of the plaint and the written statement and the orders, my lord. That certified copy, my lord, has not been handed over. So our grievance.
You could have made the state a party. You could have made the registrar of this court as a party.
Registrar is a party,
of
my lord.
This court a party.
The judgeship and the registrar are parties, my lord.
And 2023, aren't the orders up there in the server?
My lord, not only the orders, my lord, the plaint and the written statement. What happened, my lord, the erstwhile board, it was there with the erstwhile board. The present board does not have, my lord, the copies of the plaint and the written statement.
It is certainly there, but then it has been taken away and not handed over to you. This is the reason you are over here. The papers cannot vanish in that manner.
We have been informed that the record department has not, my lord, the record has not reached the copying department.
Please come. None represents the. Show me the service.
My lord.
None represents the respondents. Stop. Affidavit of service taken on record. Stop. Let a notice be served on the respondent number 2, intimating that the matter will appear in the list on 8th April 2025. Stop. The respondent number 2 is directed to ensure that the certified copies applied for by the petitioner are delivered prior to the adjourned date. Stop. Let this order be communicated to the respondent number 2 forthwith.
Grateful.
Lord, I appear for the respondent number 5, my lord. I am supporting the petitioner.
You are supporting.
Because we are a JV, my lord. I am one of the partners of the JV. So there is an interim order subsisting. Lord, what happened is it was a tender.
Let me hear first. You are the private respondent.
I am
Yes,
supporting
please.
the case of the petition.
Lordship, there was a JV entered between me and the respondent number 6. Subsequently, the state respondents flouted some of the rules and terms of
State respondents.
yes, some of the terms of the tender, Your Lordship, subject to clause 25 of the RFP document.
My lord, I'm there appearing, my lord. I'm leading Mr. Kabir, who's there. My lord, I'm there, my lord. May I just take over, my lord?
Lordship, I am being led by him and our senior, Mr. Shuddhashatta Banerjee. Today, my lord, he's on his legs on a different court.
My lord, I'll be very candid, my lord. Today I was going to ask for an adjournment for the day, my lord. I'm in some
Eligibility conditions.
My lord, am I audible to your lordship?
Very much audible.
Yes, ma'am. I was asking for an adjournment for the day, my lord. If your lordship keeps it tomorrow, in fact, my senior is also there in the matter, my lord. He's also on his legs. Mr. Banerjee is leading me in the matter. I was praying for your lordship to kindly keep it tomorrow, my lord.
Lordship, we have been waiting for the hearing of this matter for a very long time. We have the judgments and everything is ready.
Then why are you not proceeding? Why is accommodation sought for? I do not know.
Lordship, I'm being led by my senior. Lordship,
We've
it's very heavy on the
It will
facts.
take time. It will take
some
some
Your
time, my lord.
Lordship.
We have to show
You are enjoying the interim order?
that we are a
We are
JV, my
enjoying.
lord. There is in. But I can
we are enjoying the
for some time, Lord, I can show the paper.
So
We have a very good case. We have a very good case,
Very
because
good
there is
case.
no
Lordship,
reason that somebody will hide.
Lordship, this case is very heavy on the facts.
State has admittedly flouted the conditions, eligibility conditions of the RFP. Admittedly, we can show it from the record.
Only thing is, what I was pointing out on the last occasion also, my lord, if your lordship kindly takes up the second page of the report.
yes.
Well, actually, the interim injunction was passed on 3rd October 2023. Prior to that,
Injunction in this writ petition.
yes, writ petition. Prior to that, the entire project work has been completed.
Entire work is complete. Now,
At that point of time, when the injunction was granted, they only placed their bills. Before that, those are pending. This will be ultimately the claim of the
But that is absolutely untrue, my lord. That is absolutely untrue. There is a vacating application that has been taken out by the respondent number 6, which is the private respondent.
when somebody is submitting, please hold your patience.
I'm
And
sorry, my lord. I'm extremely sorry. I'm extremely sorry.
as it is, you are seeking an adjournment, and
Yes.
when submission is being made,
I'm
you
sorry.
sprung up.
I'm sorry.
The issue what we were on, that the work order was given to the issuant bidder at that point of time, and my learned friend belongs to, actually he was not the JV partner. What he was not the lead partner. Lead partner was the petitioner. Yes, the petitioner.
No. Lead partner was a
Lordship, may I have
Almans Global.
He was the lead partner. They didn't have this any application or nothing. Now, the partner of him is coming up who was not the lead partner at that point of time. He only as a joint venture partner.
Lord, without interrupting Mr. Ganguly, Milord, only one thing. I have read the affidavits. This has not come in the affidavit that the work is done. This unsigned report, Milord, I don't know who is filing it, but it's not a part of the affidavit, Milord, that the state has filed.
What is the interim order that has been passed?
Lord, the 13th of January 2025. Right?
3rd
of
October.
3rd of October. Yes, 3rd of October 2023. Kindly see, Lord. Para 5. My Lord has got that, 3rd October.
Yes.
Kindly see, para 5. Accordingly, respondents shall remain injuncted from giving further effect to the tender or to the work order because the work order was made a part of the writ petition. If issued in terms of thereof till December 15 until further order 6 to file affidavit. Now, when
Now,
this
the stand of the state is that work order has already
Mr.
been
Ganguly was there,
has been complete.
that's not the stand in the affidavit. That's not the stand in the affidavit. Mr. Ganguly was there present on that day when the interim order was passed. I was not there, but it appears that court has considered the work order.
This is 23. Bid closing.
My lord, may I just make one small
Either
submission?
reply on behalf of the petitioners against the respondent number 6 opposition, my lord.
Well, the only issue is that the petitioner was neither the bidder nor the.
Lordship, may I be please permitted to file the reply?
Yes.
Lordship, I would just like to interrupt one point, which is there is no concept of lead or sub-bidder in this whole tender. This is number one. Second is, your lordship, this was a tender with respect to the planning of the project, not the execution, my lord. Therefore, this is not possible that the work has been completed because there was already an interim order against the same. These are the two major points which I would like to raise before Lord.
Lord, the work
Which
order.
portion have you mentioned that the work in terms of the work order is complete?
Well, the date of the work order is 22nd May 2023. 22nd May 2023.
Lordship, this tender is with respect to the planning of the sewage system of the entire Bengal, with divided into 4 zones: north, south, east, and west. And this is only related to the planning of the same. No execution, no brick and mortar work, nothing at all.
Who are the parties in the writ petition?
Not perhaps in the report also it's not stated.
Party to the
It is only the state. Oh no, there is a
respondent
number 6. What is your stand?
Whatever points have been urged by them, we have all the answers for them, and we can the petition can be urged. If they complete that,
What is your stand?
But their repetition is on the 3 points: on the issue of originum, on the issue of there is a manpower duplication that they have alleged us, and they have said the issue.
Are you the successful bidder? Work order issued in your name. Have you performed the work? Is the work complete?
No.
Then
the work is still proceeding, and there is an interim order. How are you proceeding with it?
Whatever has been proceeded prior to the interim order, till that time the work was done. Nothing has been done.
Thereafter, nothing has been done. All right. Please stop.
It is saying it is done.
Accommodation has been sought for. On behalf of the learned advocate representing the petitioner.
Scan
Stop.
scan
It appears that an interim order is already subsisting in the matter. Stop. The matter is required to be heard. list in the combined monthly list of April 2025 under the heading for hearing. Stop. The interim order that is subsisting is extended till 31st of July 2025 or until further order, whichever is earlier.
My lord, grateful.
I'm grateful.
What is IA Can 1?
Application for the vacating of the interim order.
Lord, it was on the last occasion, it failed from them, your lordship, Lord, that on the affidavit, it also held the entire matter.
Yes.
Grateful.
24.
Item number 24. 24 minute, I beg to appear for the petitioner.
Yes.
Indian Oil Corporation is the answering respondent, Lordship. My lord, issue is, my lord, regarding distributorship of my LPG, my lord, distribution license. My lord, there was an advertisement in the year 2019. The petitioner applied for that. The decision was taken by draw of lots. My lord, thereafter, my lord, documents verification took place. 2-point verifications were there, my lord. One is with regard to land you were offering for go down. I passed. But so far the land I offered for, my lord, the showroom, I was caught. Why? Because the guideline says that it has to be a registered document. And secondly, if it is a lease deed, it has to be 15 years from the date of the advertisement. So my document which I offered for the showroom land is a notarial document. So, my lord, that is my, if I may respectfully invite your lordship to page 54.
What is the position now?
As on date, my lord, as on date is the update.
Yes, my lord. Fresh draw will be conducted and distributorship. Let him complete, my lord. I will substantiate, my lord.
So, my lord,
guidelines requires that certain restrictions are there regarding the eligibility criteria, my lord. They have to fulfill the eligibility criteria. Unless they fulfill the eligibility
and
criteria.
fresh draw of lots in respect of the same area?
Yes, my lord.
And petitioner is eligible to participate?
No. His candidature has been rejected.
Fresh draw of lots, he can always apply?
No, my lord. Not. There are certain persons, my lord, applicants. In the initial stage, he was selected in the draw of lots, in the first draw of lots, my lord, for which FVC was conducted, my lord. Since his application has been rejected, so a second draw of lots amongst the remaining eligible candidates.
Now it will be the remaining candidates draw of lots?
Yes.
All right.
but my lord, my representation, my lord, may I peacefully invite your lordship, my lord. Now, first, my lord, communication comes, my lord, from the authorities at page 24.
Yes.
Kindly have a look, my lord. If I may respectfully invite your lordship to page 24, my lord. They say, my lord, on 6 March 2024, documents pertaining to eligibility regarding ownership of land offered for construction showroom. Kindly see, my lord, on the basis of the field verification of credentials by the undersigned officer and further going through the documents pertaining to location Valpai, the following points need to be highlighted. It is submitted copy of notarized lease document in page 24. Support of your offered land for showroom construction number so and so is not registered. In view of the above observation, it has been found that the offered land details in the application for construction showroom do not fulfill the eligibility with respect to ownership of land criteria as per the guidelines laid down in the brochure on unified guidelines for selection of LPG distributorship. Hence, since the offered land does not meet the eligibility, but failing in the advertised location, you are advised to submit land related documents for any alternate piece of land, if any, you do have. Now, my lord, kindly sees, my lord, my next communication with the authority. Pursuant to this, my lord, they come for verification again, and my lord, kindly sees page 61. Although page 24 says that on the basis of your field verification credential, which they in short called FBC, but at page 61, kindly sees, my lord, they come on 15th March, kindly see at the bottom.
Yes.
Their officer is receiving my document. Kindly see the nomenclature of the document, my lord. Details of land offered by the appellant for LPG go down, tick mark, and my lord, page 62, my lord, for showroom. So their officers are receiving it on 15th March 2023. All on a sudden, my lord, comes page, my lord, next page, 63.
63 is your communication.
I am lord, sorry, I am giving representative. What? After giving this to the document, after giving the documents at page 61, 62, they advised me you prefer one representation. So I preferred a representation. Kindly see the contents of my representation, my lord. I so and so confirm that I do not have any other alternative piece of land for showroom which is registered before the date of submission of application on so and so. So I am requesting you to kindly consider the offered land, sir. By mistake, the land deed has not been registered, but I confirm that if I get the LOI, letter of intent, I will make the land registered. That was on 14 March 2023. Suddenly comes, my lord, this, my lord, page, my lord, 54, that is the 64 impugn notice. This is my impugn notice. We regret to inform you that your candidature for selection of LPG so and so is at variance. Observed, offered land for showroom does not fulfill eligibility criteria with respect to ownership of land is concerned. You are unable to provide alternate land during so and so. So, my lord, this is my impugn notice. My contention with your lordship respectfully is this, that page 63 has not been taken into consideration, that whether that if I get the LOI, I will make the good loss, I will get it registered. That has not been, my representation has not yet been considered.
Why will it be considered at the very first place? Because the terms and condition mention that a registered deed is required to be shown.
My lord, may I pose this question to myself? My lord, am I not entitled to get an opportunity hearing? My cancellation takes place.
No, you do not fulfill the condition, you are out. It is as simple as this. If this goes on, then the process by the authority can never be concluded. This is the main thing.
Public utility service cannot be stalled.
Right. See, from 23 till 25, they are unable to conclude it. It cannot be done. Please come. The petitioner challenges the communication made by Indian Oil Corporation Limited on 15th of June 2023, intimating the petitioner that his candidature for selection of LPG distributorship stood cancelled as he failed to fulfill the eligibility criteria. Stop. Paragraph. One of the eligibility criteria for obtaining the distributorship is that the applicant should possess a land registered in his name. Stop. Admittedly, the land offered by the petitioner was not registered in his favor. Stop. The petitioner made an application requesting the authority to accept the land. And if the land is accepted, then the land will be registered. If the
LOI.
If the not land is accepted, and if the letter of intent is issued, then the land will be registered in his favor. Stop. Learned advocate for the petitioner submits that such request made by the petitioner has not been considered by the authority. Stop. Prior to cancellation of the candidature, the petitioner ought to have been given an opportunity to make good the defect in the land offered. Stop. Paragraph. Now, it has been submitted that there has been violation of the principle of natural justice. Paragraph. Upon hearing the petitioner and upon perusal of the documents annexed to the writ petition, it appears that admittedly the petitioner failed to meet the eligibility criteria for obtaining the distributorship. Stop. Paragraph. The petitioner has sought to set up a new condition for condition before the authority to issue the letter of intent and thereafter go for registration of the subject land. Stop paragraph. The petitioner alleges that there has been violation of the principle of natural justice. Stop. The said contention of the petitioner cannot be accepted by the court. Stop. The terms and conditions and the eligibility criteria is clearly laid down in the advertisement. Stop. Any
Brochure, my lord.
Acha, and the brochure.
Yes, my lord. I'm handing it over, my lord. The full
No,
name
you
is
keep
here.
it with you, no use.
Lord.
And the brochure relating to the grant of LPG distributorship. Stop. If any relaxation is shown to the petitioner, comma, the same will be in deviation of the terms and conditions, and the same will not provide a level playing ground to the other applicants who had applied in response to the advertisement. Stop. The petitioner was made aware by a communication dated 6th March 2023 for offering alternate plot of land duly registered in his name. Stop. The petitioner failed to provide any such land. Stop. There has not been any violation of the principle of natural justice. Stop. The writ petition fails and is hereby dismissed.
$25, my lord. I am appearing for the petition, my lord.
Yes.
If it may please your lordship. My lord.
Is it a tax matter?
My lord.
Why will it be heard by this bench?
Not a.
We are the respondent number 9, and
Ah.
respondent number 9 has no role to play in this.
My lord, they are necessary party, my lord, for the
They are
adjudication.
necessary.
Lord. But my main claim is
Answering
against the
respondent?
BSNL, my lord.
BSNL?
Is respondent number 4, my lord.
Did you
In the
serve anybody representing BSNL?
My lord, must be. We have already served them, my lord. If I may file the affidavit of service, my lord. My lord, what has happened, my lord? My lord,
Ministry of Finance Service through the Office of the Additional Solicitor General. From when?
my lord,
This is not the way you are to serve.
someone was appearing for the BSNL, my lord.
Who? Where is it? I do not find anybody's name.
My lord, it must not be appearing in the order sheet, my lord. But
Then?
I have been instructed by my learned advocate and record. Someone from the BSNL have contacted her. She is not available because of her marriage, my lord. She is not available. That's why, my lord. My lord, if I may.
So if the advocate concerned is getting married, so it's a good ground to adjourn the matter, isn't it?
It is, my lord.
Then?
But the only difficulty is that, my lord, on the last occasion, because as I was going to bereavement, my lord, adjournment was sought on my behalf, my lord.
Yes.
And my lord, the issue involved is very small, my lord. What has happened if
In the absence of the other side?
If your lordship kindly allow me to issue a notice requesting the BSNL, my lord, thereafter, if your lordship can fix.
What is the role of the CGST authority?
If I may be permitted to submit 2 lines, my lord. My lord, what has happened, my lord? My IGST output has been withheld by the BSNL authority, my lord, arbitrarily. Now, my lord, I have already paid that IGST because I was a trader, my lord. The petitioner was a trader. He used to procure the biometric from one of the manufacturers and he used to sell it to other purchasers, including the BSNL, my lord. 730 odd machines were being supplied to BSNL, my lord. What BSNL did, my lord,
Please come. None appears on behalf of BSNL. Stop. Let notice be served upon the learned advocate representing the non-appearing respondents. Released on 25th of March.
2050 My lord, can it be on 26th, my lord? I have
All
some
right,
pre-
26th of March. See, BSNL authority has refused. And you say learned
Oh, my
advocate is
lord,
appearing?
someone has contacted, my lord.
Someone is the learned advocate or who is?
Learned, who introduced himself as to be the learned advocate appearing on behalf of
Very
them.
well, affidavit of service is taken on record. The unserved writ petitions are handed over to the, not handed over, returned to the learned advocate for the petitioner for onward transmission to the learned advocate representing BSNL. Stop. The unserved envelopes, however, will be retained with the records. This will be opened, take back the copy, the envelope will remain.
Much obliged, my lord.
Item number 19, my lord. So you just passed over. My lord, I am agree.
Item number 19 is not being called on now. You have to wait. Yes.
Your Lordship, Your Lordship, my learned senior, Mr. Pranit Bagh, is engaged in this matter, Your Lordship. It's absolutely unfortunate, but Mr. Bagh had to leave after the first half due to personal reasons. Usually never tells his juniors to actually take time on his ground, but Lordship, it's something very urgent came up. Otherwise, Mr. Bagh would not have left. And on that ground alone, Your Lordship, I'm asking for an adjournment today, Your Lordship.
Adjournment for how many days?
Lordship, the matter can come up tomorrow also, Your Lordship. Just today, Mr. Bagh had to leave.
What is it?
This is adjourned for quite a long time.
Lordship, it's for the second time that the adjournment has been taken on previous.
2023, it is in motion
23
stage.
writ petition.
It is in motion stage.
Previous
Yes.
occasion, Your
And
Lordship.
there is another important.
Apologies, Your Lordship, but on the previous.
Lordship, kindly take paragraph 4.1 at page 3 for once. This read petition itself is not maintainable. Their own government.
Lordship, I'm only
Company
going
has
to.
been in liquidation.
I'm only going
The
to pray.
property belongs to the company.
I'm only going to pray before.
Kindly see 4.1.
Yes.
He was erstwhile director.
I'm only praying before Your Lordship to kindly take up this matter on any other day.
Make this
It's extremely
decision
difficult
maintainable.
today, Your Lordship. Had I known the facts, I would have made better submissions, Your Lordship, but I'm in no position today. The challenge in this writ petition, however, if Your Lordship.
An accommodation has been sought for on behalf of the learned advocate representing the petitioner. List on next Monday.
Lordship.
Record appearance of the respondents. 27.
May it please your lordship.
Yes. State who's appearing? All right.
Lord, this is appointment of a second
Private
MM.
respondents?
Lord, we have served. The affidavit of service is here, but I think press service will be required because it's long
Track
back.
report.
No, that was served.
Track report is also there. What is your prayer?
Lord, prayer was that
Service টা রাখুন।
prayer was that they should not appoint anyone as a second MMR. Second MMR in the same police station, because one MMR for each police station is sufficient, and there are other orders also where the policy decision is to be taken by the state. That policy decision has not come.
According to
Is there any bar for appointing second MMR?
No, the section 3 of the Bengal Mohammedan Marriages and Divorces Registration Act specifically states 3. May I please? I am having only one copy.
No, you read it
Shall
from
be
there.
lawful for the state government to grant a license to any person being a Mohammedan authority, authorizing him to register Mohammedan marriages and divorces which have been effected with certain specific limits on application being made to him for such registration. And in like manner, it shall be lawful for the state government to revoke, suspend such license, provided that no more than 2 persons shall be licensed to exercise the said functions within the same limits. Act specifically states, my lord, this is
That is part of the
marked,
petition also. I have put it in.
Petition also. So 2 persons can be affected.
No. There, my lord, a similar matter was considered by the other learned single judge. Lordship will see this order.
ওখানে কি দেখাচ্ছে দেখেন। Yes.
No, this is a fresh copy, my lord.
Doesn't matter. I can see it from here.
A bit marked, my lord.
Doesn't matter.
Section 3 at page 4.
There is an impugned order over here. Is there any order that you are impugning?
This was a similar matter was considered by the learned single judge, my lord. Paragraph 10. Your lordship will kindly come to paragraph 10. একটা অন্য order ছিল, একটা অন্য কেসেতে। আমি দিচ্ছি আপনাকে। They had prayed for appointment of a second MMR. The court said no, I'll not.
The court records section 3 nowhere mandates the state to appoint more than one MMR for a particular territorial limit. Where from is the court getting it?
But let me see. Section.
Section 3 has been read out.
Milord, page 4 of section 3. Milord, in my petition, page 4, Milord, I have set it out.
Yes.
Milord, they proviso. Provided that now no more than 2 persons shall be licensed to exercise the said function within the same limits. Provided it is Shia and Sunni, but there is no scope of Shia and demarcation of Shia and Sunni. As a result, Milord, normally both anyone can function for both Shia and Sunni. Now, therefore, Milord, we have said that don't appoint a second MMR. This was in 2023, Milord, it was filed. And they have not appointed. Rather, what I have come to know is that they have rejected the cases, but then I don't have anything on that.
What remains in the writ petition? Your relief that you are claiming is circuitously given to you.
No, no, no.
Not directly.
No,
but in a circuitous manner, you are getting the relief.
We are saying that don't appoint a second MMR where
They are not doing it.
If they don't do it, Lord, I have nothing to say.
They are not doing it. As of now, they have not done for the last 2 years. And you
That's
say
right,
that the
Lord.
prayers are rejected. Then what remains in the writ?
But she will record that, Lord.
Please come.
My lord, kindly, in this order, as I was just looking it out, paragraph 16, my lord, kindly, for once, my lord, kindly have a look at this.
Yes.
Of the judgment that has been judged right now placed. However, nothing in this order shall preclude the state respondents in the event so felt necessary
Please
to
come.
create a second vacancy for which the state respondents follow the established procedures.
Petitioners have filed the instant writ petition praying for a direction upon the state respondents not to engage more than one Muslim marriage registrar within the jurisdiction of one police station. Stop paragraph. The learned advocate representing the state respondents relies upon the Bengal Mohammedan Marriages and Divorces Registration Act, 1876. Stop. Section 3 of the said Act mentions as follows. Set out 3. Paragraph. The instant writ petition is disposed of by directing the state respondents to act strictly in accordance with the provisions of law.
And exactly that has
Service
been
is
held
taken on record.
from each sect one. Is
Yes, next.
I'm grateful.
My lord, I'm for the respondent now 11 and 12. No, I'm paying for 1 week accommodation, my lord. Because of the reason on last Wednesday evening, I got this writ petition, my lord. It's a Delhi, a Bombay-based company, my lord. I need a week time to get the instruction as well as vocal number.
My lord, one
When
thing
did you
also
serve?
verify, my lord.
When did you serve?
My lord, on the last occasion, my lord was directed to serve me, and I subsequently I have
And
served.
previously you did not serve.
My lord, I do not remember whether I am served or not, but
There is no proof of service.
no, my lord, that
He
is
has received it only 1 week back and he seeks time.
no. I am not disputing. Here is I have a required instruction, my lord.
Learned advocate represent, yes.
What is happened, my lord? The mobile tower installed by the respondent number 9 and 10. That company is not existence. And
Has no
subsequently-
existence.
No, not existence.
Acha.
Subsequently, a notice has been issued by the respondent number 11 and 12. That has to verify that the company has been merged or not. Otherwise, I have lease agreement has been made with the respondent number 9 and 10.
Are you anyway connected with 9 and 10?
It has been taken over by 11 and 12.
Taken.
I will, on the next
I'm
occasion, I
just
will
confirming that
produce
it's
the ROC's latest statement and about the statement of merger also.
Acha. Who is representing the telecom authority?
The affidavit of service be kept.
State, take
How about the state?
instruction. Take instruction who represents the telecom regulatory authority. This is regarding setting up of mobile tower or what? You have got a new.
There is dispute between two brothers.
Civil dispute
regarding distribution of money.
I will
Once
tell
they
you.
were together.
Now separate?
Yes, now separate. Now
Yes.
No, my lord, that is not the
no
issue.
prayer
My
in
lord,
the-
kindly heard me once, my lord. No, not like that dispute. My lord, lease has been made in the year of 2008 and expired in 2020. Since then, the mobile tower has been become inactive. They did not renew the lease. Do not maintain the mobile tower. If any undue incident has been happened, then liability becomes upon the
Who is
petitioner.
lesser?
Initially, my lord,
Who is the lesser?
brothers have the rate lesser. Subsequently, one brother transferred.
You all are the lessee. Who is the lesser?
This net matter.
Lesser to petitioner is the lesser one. Oh no, lesser my client 9 and 10. Sorry.
9 and 10. This
Yeah,
network. This
9
network.
and
9 and 10.
9 and 10.
Yes, my lord.
9 and
Which
10
has been
taken over
acquired by
by 11 and 12.
Yes, madam.
Yes, my lord. And my point, my prayer is that, my lord.
Did you not renew the lease?
No, my lord.
No, my lord.
The thing is this, I have a counter claim. Lease was executed in between the two brothers and 9 and 10. In the meantime, there is a dispute, as my learned senior friend has pointed out. I have not given any opportunity for a indefinite period to enter into the spot and to fix this tower. My company has suffered financial loss. I have a counterclaim. To avoid that, they have approached before your lordship. It is a civil dispute in nature. My lord knows.
No, my lord.
Even after the
Partition deed has been registered. Among two brothers,
If
partition.
there is no valid subsisting lease agreement, then the mobile tower cannot function.
No, that issue.
Yes, my lord. Mobile tower.
By the writ code, my lord.
Nobody is deciding
I have
it,
made
but how
complaint
are you
before the district
permitting the
magistrate.
authority person concerned to continue with the mobile tower without a valid?
I will substantiate.
Your claim is there. You can go and implement your claim before the competent forum. Why will the writ court entertain all these things?
And with my respectful submission before you, whether petitioner is having any claim before your lordship.
The petitioner's case is that you are permitting someone to run the business without a valid license. This is what his case is.
That is absolutely subject matter of private dispute. How
My lord,
court can interfere?
My lord, I have made complaint before the district magistrate. District magistrate is the appropriate authority.
That is also is not his case. His case is the authority, the telecom authority is not maintaining the tower, but it may cause any kind of injury at any point of time.
All right. Where is
either remove it or
where is
maintain
the complaint before the DM?
My lord, page number 52.
52, show
Annexure
the
5.
proof of service.
Huh?
Proof of service.
Yes,
please.
my lord. Affidavit of service I have filed.
Please come.
My lord, that complaint
A
till
complaint
pending.
was lodged by the petitioner before the District Magistrate South 24 Parganas with regard to the activities of the lesser in maintaining the mobile tower. Stop. The said complaint is pending consideration. Paragraph. Learned advocate representing the lessers submits that there is a counter claim against the petitioner. Stop. Paragraph. Be that as it may, as it appears that a representation is pending consideration before the DM with regard to non-maintenance of a mobile tower. Accordingly, the instant writ petition is disposed of by directing the district magistrate to consider the representation filed by the petitioner, dated 25th of April 2023, in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties and by passing a reasoned order. Step. The aforesaid respondent shall communicate the reasoned order to the parties immediately thereafter. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Step. Learned advocate for the petitioner is directed to forward a communication dated 25th April 2023 to the aforesaid respondent at the time of communicating the order of the court.
Grateful, my lord, affidavit of service be kept with the record.
Yes.
Well, this is my application, Lord.
Yes.
This petition has been filed, my lord, entirely challenging.
My lord, I am appearing on behalf of the Union of India, led by Mr. Sovik Nandi.
Yes.
Lordship, this petition challenges, Lordship, the Any Property Amendment and Validation Act 2017 on the grounds of several grounds, including
you are challenging the act itself.
Amendment Act, Lordship.
Amendment Act.
Amendment Act of 2017. It came into force on January 27, March 2017, Lordship. Lordship, on the last occasion, I believe my learned friend had submitted, my lord, there are several proceedings pending before the Honorable Supreme Court of India on the same issue. Though I have not been provided with a list of the pending litigations, my lord.
My lord, I have the list.
Pending?
Pending. Several cases have been pending.
Whether the same issue is under challenge in those petitions, Lordship, I do not know.
Please come. Provisions of the what is the name of the act?
Enemy property within bracket amendment and validation bracket close.
Where do I get that? In the prayers?
Lordship.
Enemy property bracket open
Lordship,
amendment and
53,
validation bracket close Act 2017 are impugned in the instant writ petition. Stop. Learned advocate representing the Union of India places a list before this court.
একটা কপি দেবেন আমাকে
mentioning that the constitutional validity of the act is already under consideration before the Honorable Supreme Court. In view of the same, the writ petition stand delisted for the time being. Stop liberty to mention. Give a list to him.
Lordship, please to join it, sign it, Lordship.
Delist liberty to mention.
Lordship. I'm so grateful, Lordship.
Now, in last item number 28, my lord, petitioner is the owner, lessor, and my client, respondent number 11 and 12 are the lessee.
All right.
It has gone down some typographical error.
All right.
Grateful.
Last option, I am for the state, my lord. Like by Mr. Amolson. My lord, last option, Lordship directed to report instruction. This is my instruction, my lord.
What is the matter about?
My lord, it is the matter where the right to information has been sought for recording of the land in name of the outsiders, my lord. The BLR in the at page, my lord, may kindly recall, my lord, it is a very interesting case at page 31, where the BLR has stated, has given a reply in terms of the order of the appellate authority, claiming it to be appellate authority, but no reflection of this appellate authority's order has been reflected, my lord. Kindly, if my lord comes to the page 31, it will.
What is your query, page 29?
Query is at page 17, first query.
Page 17, page 29, you mentioned on the last occasion. It is recorded in the order.
Page 29 is met.
Query at page 29.
Page 29. Page 29 is a page 29, my lord. That is also, my lord. Since this is a continuing cause of action, page 29 will also suffice, my lord.
Sridhar, how this
Plot number is RSLR, plot number is 330,
330
classified as Bilan in Mauja,
Bidhushan Senapati and these
is vested to the state, West Bengal Estate Acquisition Act. Proceeding 5A, determining the nature of transfer of the intimate is not hence ineligible for compensation. Lot with full share was incurred for the rupees of non-material. Please come. Peruse the report forwarded by the Block Land and Land Reforms Officer, Minakha, North 24 Parganas, dated 13th March 2025. Let a copy of the same, along with the annexure, which is the copy of the record of rights, be forwarded to the learned advocate representing the petitioner. So, released on 20th Thursday. Come ready with instruction. Possibly your query will be answered. 31. 31.
For the state.
Dismissed. Record appearance for the state.
I'm for the petitioner, ma'am.
Yes.
My lord, petitioner seeking quashing of the FIR, my lord, on basis of the Supreme Court judgment. My lord, kindly come to page 22. Annexure P2, P3, my lord. P2, my lord. Page 20. The petitioner lodged complaint on 15th of August 2023. My lord, kindly see the time, my lord. At 005 hours. Against one Giyasuddin and Soifuddin. And my lord, case has been started under section such under provisions of IPC. And thereafter, my lord, after few hours, after the case has been registered, Giyasuddin went to the police station and lodged complaint against me, my lord. I am a government servant. My lord, kindly come to page 24, my lord, P4.
Yes.
My lord, there is a judgment. There is a landmark judgment from the Supreme Court on 2nd December 2023, where State of West Bengal has already filed their affidavit for filing undertaking that they have installed the CCTV camera in all police stations. My lord, kindly come to page 27, my lord. Flash item B. My lord, kindly direct the state to produce the CCTV footage. My lord, after the case has been registered, how the offending person went to the police station and police registered their case without arresting them.
What is the status of the criminal case?
On the last occasion, my lord, I am not able to contact with the petitioner, my lord, but on the last occasion, my learned friend on the state, my lord, they submitted that charge sheet has been submitted.
It was with just the last report, but now the present report says, my lord, 2 complaints has been made by the petitioners.
Yes,
2 complaints.
2 complaints. One on 19th
P1,
July
P2.
2023, and thereafter in the second page of the report on 15th August 2023. In both the cases, my lord, charge sheet has been filed. FIR was registered and charge sheet has been filed. Thereafter, on 16th of August, my lord, this Sheikh Giyasuddin came to the police station and lodged a complaint against him.
By
There
that time,
also, my lord,
FIR already registered.
FIR has
against him,
been
my lord.
registered. Yes, and FIR has been registered, my lord.
An inquiry, investigation?
Everything has been done, my lord. They have surrendered before and the matter is pending before the CJM, my lord. Kindly appreciate, my lord. It has been stated over there, my lord.
Has any bail been obtained?
Bail been obtained from there, from the court.
Bail obtained?
Yes. In CJM, Purva Vardhaman, my lord. Learned CJM.
Madam, I'm kindly ask for the relevant time CCTV footage, my lord.
See, it cannot be preserved for an infinite period of
My lord,
time.
kindly see, my lord, when it was filed, my lord. When it was filed on 2023, my lord.
And what
Kindly
steps
see
did
the
you
report,
take?
my lord, when the respondent number 4 prepared the report, my lord. Kindly see the
What
date, my lord.
steps did you take in between? Why did you not make a prayer before the learned trial court for production of the CCTV footages? You did not make any prayer. At this stage, can this order be passed? Please come.
My lord, may I have the copy of the report, my lord?
Peruse the report filed by the officer in charge, Memari Police Station, Purva Vardhaman, signed on 3rd of March 2025. It appears therefrom that the investigation of the subject case has ended and charge sheet against the accused was filed, being Memory PS charge sheet number 893/23, dated 31st of December 2023, under sections 447/504/506/323/34 IPC. Stop. Trial is currently pending before the learned Chief Judicial Magistrate Purva Vardhaman. আচ্ছা, শুরুটা কি দিয়ে করলাম বলুন তো? Subject cases have ended. Charge sheets. ওটা হচ্ছে দুটো হবে, একটা 893 বললাম তো, তার আগে একটা হবে 678/2023, dated 30th September 2023, under sections 341, 323, 506, 34 IPC. আর নিচে trial of both the cases are pending. CJM, Chief Judicial Magistrate, Purva Vardhaman. ঠিক আছে? The petitioner prays for production of the CCTV footages. Stop. The instant writ petition is disposed of by granting leave to the petitioner to approach the learned Chief Judicial Magistrate for necessary order. Stop. As the charge sheets have already been filed, the court is not inclined to pass any further order in this matter at this stage. Disposed. Let copy of the report filed by the police be handed over to the learned advocate representing the petitioner.
And the report filed here, we kept on the record. No?
Yes, report is taken on record.
Grateful.
Grateful. 31, my lord, item number 31, my lord, I could not reach in time, my lord. Item 31, I am for the petitioner.
So it has been dismissed, you were not there. Your other side was present.
Kindly make
Bring
it
your
not
other side. Your other side was present. Bring him. কি ছিল নামটা? এই 31
on the earlier occasion, leadership has directed.
31 এ কে ছিল প্রদীপ? পিটিশনারের এই রেসপন্ডেন্টের জন্য? 31
I am calling.
Indranil Roy and Taposh Kumar. Go immediately call him.
I'm good. I'm calling.
Well, in this matter, I am appearing on behalf of LIC.
Yes.
We are for the petitioner. That the petitioner's mother, during her lifetime,
Pradeep.
petitioner's mother, Malti Devi,
Yes.
just all, during her lifetime, opened two LIC policies, in the year of 2012. Thereafter, my lord, extremely sorry to say, my lord, she expired in the year of 2015. Thereafter, son was the nominee. She naturally filed a claim case, my lord, before the authority concerned. It has not been considered. Thereafter, my lord, filed an application before this Honorable High Court petition. This Honorable High Court was pleased to pass an order, to pass a reason order within a stipulated time. Thereafter, any order has been passed. Thereafter, paper and appeal. Appeal has not been considered within time. Thereafter, further petition was filed. Further, my lord, same order was passed to as especially as to dispose of the same. Thereafter, appeal has been disposed of, filed before the ombudsman. Thereafter, ombudsman, my lord, the pass an order, my lord, kindly see the page 77 onwards. That is the last page, 78, last page.
What is the conclusion? Your
Conclusion is
claim has
suppression
been-
of fact, my lord. That is the my lord, actually stereotype order, my lord. Stereotype suppression of fact. When the policy was there, at that time opening, ought to have taken, my lord, measure physical condition, medical test, ought to have taken, obviously taken up at that time. Now, my lord, they have to give the payment, compensation. Now they are saying, my lord, it is suppression of fact.
And your lordship.
And your lordship knows it very well. It is each and every matter they are saying suppression of fact.
Well, your lordship, kindly see the page 32. The first order, as per Honorable Court's order, the LIC authority, your lordship, kindly see the page.
Yes, 32.
32 is the order of the Honorable Court. As per Lordship's order, before this Honorable Court, the facts of the cases, your lordship, kindly see the page 35. This is the appeal which has been disposed of upon giving opportunity of hearing to the.
No, it is all right. You say that there has been suppression of fact.
Material fact.
Now, how could you proceed with the policy at the time of
Yes.
initiation of the policy? You accept the money and then the policy starts.
Not that. Your lordship, kindly see, your lordship knows the insurance, contract of insurance, including the contract of life assurance of this policy. That contracts are aberima fide. That is, my lord, utmost good faith of the policy holder. And my lord, that's why, my lord, your lordship, kindly see the as per contract, there is specific direction. They have stated that all materials are disclosed, which has been true and correct. There is a provision is there. But my lord, your lordship, kindly see, he has, my lord, he has stated that, your lordship, kindly see that.
When did the policy start?
2013.
12.
2012.
Very well, 12 or 13.
Yes.
And the person concerned expired in 2015.
Yes, my lord, within 2 years. 2 years and 5 months. That is, my lord, as per section 45 of Insurance Act, which is clear stated, within 3 years, if he died, then, if he died or contract, my lord, a policy, your lordship, kindly see the no policy of a policy of life insurance may be called in question at any time within 3 years of the. And my lord, she has stated that he is good health. Regarding health, my lord, he has stated, wrongly submitted, that he is our health is good. This is the suppression.
How did you know that the health was bad?
Yes.
Kindly see, there is no affidavit. That's why, my lord, as per he has died on 23rd of July 2015 at Sri Jain Hospital Research Center. And at their report, we have come to know that he is the acute chronic disease, kidney disease. And that's why he has died on
23rd July of 2015. If your lordship kindly give me the to file affidavit, I can say elaborately.
After death, my lord, they are showing agreement, several sections, several provisions.
My lord, this is
At the time of receiving the amount, when it was opened, my lord, there is no provision. There is no provision, there is no agreement. Just to go the counter and to deposit the same.
Regarding this type of, there is so many order of
For
the
2 years, my lord, this was not there.
order passed by the
My health
Supreme
is
Court.
good.
Your
At
lordship
that
kindly
time,
see once-
at that time, my lord, what to have, there was a medical test. Obviously, it was
No,
test.
no, my lord.
Yes,
You
it is
have
your
to
duty.
state
It is
it.
the duty of the
You
LIC.
have to
When
state
it has
it
been
that
opened,
he has kidney
your
disease.
health is not good.
Y'all have the benefit of doctors who check the health of the patient,
If I
insured person.
if I have a patient of cancer, then I have to state it. Otherwise, there is so many diseases are there.
Don't you all check up the health of the insured
lord.
person?
Preliminary.
Yes.
Preliminary, you checked up
Yes.
and you did not find anything?
Chronic kidney disease, my lord. If
Chronic
it's
kidney
suppressed-
disease you could not detect.
If it's suppressed, then it cannot be.
Where is the question of suppression? Your doctor failed to find it out.
No, my lord. There is. He has stated that he has good health. She has good health.
Obviously, the person who intends to obtain a policy will state that.
But my lord, as per Supreme Court judgment,
Please come.
Supreme Court
The
judgment.
petitioner
your
is
lordship
aggrieved by the
Court judgment letter.
order passed by
But
the
the provision, natural justice.
LIC ombudsman. Not LIC, but insurance ombudsman.
Insurance ombudsman also
Rejecting the prayer of the petitioner.
This is only one
For
my lord, there is two policies. There are two policies. Ombudsman, he has gone only one policies.
what about the other?
What about the other? Because there is no scope. Ombudsman has only 30 lakhs, while this is 37 lakhs. And that's why one policy is 37 lakhs, 37.5. Another policy is 12.5. He has gone to the 12.5, that policy.
Very well, then what will happen to the other policy?
Same, my lord. We have repudiated
Suppression of-
same cause of action.
Yes, same cause, separation of them. To give,
Naturally,
to give the
other
time,
Company,
to receive the amount.
LIC,
No
the
provision, no
insurance ombudsman refusing to grant relief of the policy on the ground of suppression of material fact at the time of initiation of the policy. Stop paragraph. Learned advocate representing Life Insurance Corporation of India seeks time to file a report. Let report by LICI be a report by way of affidavit hobe. Be prepared and circulated by 17th of April. A reply, if any, by
17th of April.
April.
Today is 17th
Today is March. April. Reply, if any, by 30th of April. List in the combined monthly list of May under the heading for hearing.
Contested hearing matter, my lord.
Hearing.
It will be difficult to take up the matter.
There are other benches also. You can try your luck. Yes.
Or fix the date, my lord, then it will come, my lord.
34.
34, my lord, I'm for the petition.
Yes.
I'm paying for adjournment, my lord. Because of that, my beef has lost. I've already applied for the certificate of the liquidation, my lord. Your lordship kindly.
Who is your other side? Are you aware?
No, my lord.
Was it served?
No, it is not served.
34. Not,
I've applied for the certificate copy on 11th of March, my lord.
it can never be given because the file is over here. How can the certified copy be given?
My file may be gone down to department, my lord.
Who is your, did you serve or not serve?
I'm not sure.
Not even
Teacher,
served.
not-
Let me dismiss it. You take out further petition. What is the use?
My petition
From
is
23, you are not proceeding.
in a short period, my lord, let the matter appear in the monthly list of April, my lord. In the meantime, I got the certificate.
Remember issued by the STO. Cancel the same. The writ petition has become infructuous by now. The writ petition has become infractious.
So logically can be some time. Let this matter appear in the monthly list of April and get the certificate copy of the writ petition.
Learned advocate for the petitioner seeks accommodation. On such prayer, released in the monthly list of April. Let notice be served upon the respondents. On the last occasion also there was direction for service. You did not serve. The next time I see service is not there, your writ petition will be dismissed. Call the next one.
35, my lord, I am for the petitioner.
Yes, madam.
And let this matter be gone
My
down
lord.
to the department.
This is the affidavit of service.
Yes.
My lord, petitioner filed a application under RTI Act 2005 that the said land record, which has been changed, my lord, with some documents on 17 July 2020. And the respondent number 4 sent the reply on 27/11/2020, and in the reply to advise to the petitioner that the apply separately with requisite fees. After that, my lord, the petitioner filed another RTI application, but no reply from the respondent authority has been sent. So, my lord, the petitioner filed make a appeal before the district land and land reforms officer, Hooghly, on 1st March 2021. The first appeal hearing date held on 24th August 2021. In the meantime, the respondent authority sent a reply to the petitioner with putting some formal excuses to refrain from giving the actual information, my lord.
What are your queries?
My lord, kindly directed to the concerned authority to submit the record against the petitioner RTI application and subsequent appeal in the connection with the RTI application, my
Where
lord.
is your RTI application?
My lord, please come to page 20, my lord. Oh, no, P19. Sorry, my lord, it's 21, my lord.
Who's for the state?
So I'm led by Mr. Somnath Ganguly for the
Yes.
state lordship.
What is
I
your?
have not got any instruction. Kindly
This
give
is
me.
pending from 23 and you did not receive any instruction.
I already told my lord, but give me 1 week accommodation.
For 1.5 years, you could not take instruction. What is this? Please come. The petitioner seeks certain information under the Right to Information Act, 2005. Stop. The query of the petitioner is annexed at page 21 of the writ petition. Stop. Learned advocate for the respondent is directed to provide the information to the petitioner. to the learned advocate for the petitioner. Prior to the adjourned date, released on 8th April. Service is taken on record.
My lord, item number 31, my lord, the other side has come. Your lordship was pleased to dismiss, sir, and I have called him.
Grateful. Please wait.
My lord,
36.
Grateful, my lord.
No, I'm appealing for the petitioner, Lord.
Yes.
This is with regards to, Lord, non-payment of the last installment of maintenance of the road. The work was
Yes.
completed 2017. 5 years I'm to maintain. I'm going on carrying on this maintenance. I paid first, second, third, fourth year. Now the fifth year, Lord, there is a mistake of their portal. If your lordship kindly straightway come to the letter of the executive concerned, page 17.
Yes.
Or what is writing, Lord, may I place for your lordship, Lord? A reference above, this is to inform you that the package number so has been completed of DLP maintenance work on 31st March 2022. But last six number or fifth year's bill has not been paid to the agency named so Unemployed Engineers Cooperative Society due to systematic error in e-mark system. The all matters has been corresponded with the IT nodal officer and NRIDA. They expressed that the package is completed and logged out in e-mark system so that it will be paid in offline mode. So also noted that it's still now pending for payment in PIU logging in the system. And that's their problem. Maybe offline, online, what I'm concerned about that. Sorry, Lord.
You want your payment.
I want my payment only.
Lord, I have tried to take instructions from the authorities, that is the executive engineer. Although the executive engineer has written to the hierarchy, my lord, but my lord, I have bereft of instructions as of this day. My lord, what I was humbly praying before your lordships that my lord kindly directs the additional secretary, that is the person addressed to file a report in this matter, my lord, so that everything could be cleared. The executive engineer has forwarded the problem that they have faced in disbursing the amount. My lord, otherwise, my lord, it is bit difficult.
Please come.
May lordship kindly pardon me, Lord. By the process, 3 years now gone. But is this a way? But this the honorable court has been pleased to hold that interest has to be paid on that
The
amount.
payment of the petitioner
Lordship,
has
kindly
not been made for reasons best known to the authority. Stop. The communication of the executive engineer dated 13 September 2022 of the West Bengal State Rural Development Agency addressed to the additional secretary, Government of West Bengal, Panchayat and Rural Development Department has been placed before this court, which evidences the fact that payment is pending. Stop. Paragraph. The additional secretary
He is not a party to this petition, my lord.
I should do one thing. The secretary, Panchayat and Rural Development Department, is directed to file a report supported by an affidavit. As regards the claim of the petitioner, stop. The report shall be prepared and circulated by 8th April, released on 21st of April. Exception to the report may be filed prior to the adjourned date.
But will you supply a copy to my
Yes, I
junior
shall.
officer?
Yes.
I shall.
Great.
I appear on behalf of the petition.
Yes.
It is a matter, my lord, where I find that, my lord, petitioner mutated his name. Then, my lord, there is a, if I may say so, with the greatest respect, that there is a deed of conveyance by virtue of which one Brindavan Bishas got her name recorded. Now, mutation proceeding was initiated on 15/12/2022. Proceeding was disposed of. No order given. Now then I made an RTI. Seeking information to get a photocopy of the deed number 366 dated 30th of May 2016. That has not been applied. I only make this prayer that to supply me a copy of that, and thereafter, my lord, let the BLLRO hold an inquiry in connection with recording of name of the Thakurani Bishas. If it is found that no, that my name does not appear, they will take consequential steps.
If the plot is not recorded in your name, so you want the copy of the record of rights or what?
No, I want, Millard, insofar as the matter is concerned, what I find that, Millard, an application under RTI was made on 5th of January 2023.
All right, it was not given.
That is at page 30. At this stage, I can only make a prayer to supply me a copy of that.
But then the first appeal, second appeal, all provisions are there. Why are you here?
I say, Millard, what I say, Millard, with the greatest of respect.
And
Millard,
the prayer is something else. Kindly see the prayers.
Millard, kindly see, I want to get at page 30, I want to get a photocopy of deed number such and such, which I said. Now, Millard, if your lordship asks me about the legal nicety.
What is the legal action that you are challenging?
Millard, the action is not supplying me the copy.
This cannot be.
This cannot be, Millard. If he says so, let him
Here
produce a
the-
copy in
No,
the
my lord,
court.
here the
I
prayer is
withdraw my
something else, and
petition.
Mr. Bhattacharya has
Very
said
well,
something
then
else.
the first appeal provision is there.
Millard, I know, Millard. I say, Millard, with the greatest of respect, section 6 and 7, then 19,
Yes.
then first appeal. I know that.
Why
But, Millard,
here?
your lordship will kindly consider two things. I submit to my lord. My lord, first of all, Millard, this particular person, these rustic villagers, they are not aware of the legal niceties. This is number one. And existence of an alternative remedy, it does not oust the jurisdiction of the court in supplying me a copy.
In
What
that
I'm saying.
case, the alternative remedy forum, the alternate forum will become functionless.
No, I am not
Total
saying.
jobless if these petitions are entertained.
I say, Millard, your lordship may kindly consider that so far as the matter is concerned, that, Millard, I had purchased 20 decimals of land by virtue of a registered deed of conveyance registered on 1/11/99 at page 23 to 26. Page 23 to 26.
Very well.
Then, Millard, I mutated my name in the record of rights.
Yes.
Now, Millard, one Thakurani Bishas, what he did, Millard, being respondent number 11, by virtue of a deed of conveyance, he got a name recorded in respect of 0.12 decimals of land. By virtue of an order dated 4th of January 2023, passed by the competent authority. Now, Millard, mutation proceeding initiated. The mutation proceeding was initiated on 15/12/2022. Proceeding was disposed of on 30th of December 2023. Without considering the objection of the petitioner and without serving a copy.
That is a good ground to challenge the order of mutation.
Mutation, but Millard, equally I should, because whenever I go, Millard, kindly consider that when I go for challenging the particular mutation proceeding, there has to be something on record by which I can prove my assertions. Otherwise, supposing I say that today I am the owner of.
Where from are you getting to know that the land has been recorded in the name of the private respondent?
I went to the office.
Which office?
Millard, the office of the BLLRO.
Why is it not there in the Banglar Bhumi portal? Is it not there?
Millard.
In the Banglar Bhumi portal,
No,
the
Millard,
updated record should be there.
No. Millard, on instructions, I am submitting that this is not there. On instructions, I submit. My lord, I appeal to
See,
my lords,
I can.
and no one will be prejudiced. I say, my lord,
It's not a question of prejudice. It is, thing is this, you are aggrieved by the correction of record of rights. You have the
I have the
remedy
remedies over there.
before the
Yes,
tribunal, right?
yes, yes.
Now, if you want the information under the Right to Information Act, you've got the first appellate, the second appellate authority.
Yes.
Why the writ court will be bothered with all these things?
Now, my lord, kindly consider one thing, my lord, that this, I say, my lord, that the RTI which was made before the BLLRO, my lord, your lordship may kindly consider this thing, that the niceties of the Right to Information Act, this cannot be, my lord, known by a villager. This is a practical, my lord, I say, my
Ignorance
lord,
of law. Can the ignorance of law be
no,
a
cannot
ground
be an
to
excuse.
entertain
Cannot be an
writ
excuse.
petitions?
Lord, your lordship may kindly, my lord, I appeal to my lord, your lordship may. I cannot say that.
But kindly takes page 47, that is his representation, where my lord, he mentioned something else. In that representation, my lord, kindly come to paragraph 8, page 47.
Yes.
That my client made an application on so-and-so seeking the concerned authority to supply copy of the said deed number so-and-so under section 6(1) right here, upon which the name of Thakurani Biswas has been recorded. My client obtained a copy of the said deed online, and it revealed that there is not a whisper about the name of Thakurani Biswas, and scheduled land is different.
What will deed 366 will not come to your relief if this is the submission?
Milord, I say, Milord, if whatever, Milord, I say, Milord, what I could
Who
find.
are you?
Respondent number 11 and 12.
Thakurani
Thakurani.
Biswas. What is your submission?
That is not our deed. Our deed number is 7441 of 1992.
তাহলে তো যদি হয়ে যায় তাহলে আর আপনার কি আছে?
Thakurani Biswas bought that lawn in 1992.
If
what remains?
No, I say, Milord, that if it is that a deed of a photocopy of the deed of 366 dated 30th of May 20.
Which you have got online. You have mentioned you've got the deed online. And
Milord, I say, Milord, with the deepest of respect, I wanted to sit with the client. What I could understand that this was not given.
Which was not given? 366.
This particular deed.
366.
Yes.
But then this is the advocate's communication which mentions that the deed is available online.
And Milord, I cannot say anything.
Then
I cannot say anything.
My client is mentioned there.
Yes.
I cannot say anything.
What
I
happened?
can only say, Milord, that this is the thing which I
And
came
the
to
advocate
learn.
is standing by your side.
Yes.
আরে বলছেন জজ সাহেব আপনি যে চিঠিটা লিখেছেন সেই চিঠিতে আপনি তো বলছেন এই যে এখানে আপনি বুঝতে পারছেন না যে বাবরা কি কথাটা বললো?
Then
I cannot say anything more.
you cannot improve anything. Direction for affidavit.
এটাতে এফিডেভিট দিয়ে কি হবে? এটা দিয়ে
What will be clear?
আরে এফিডেভিট
বলুক না তারপরে আমরা
কি বলবে?
How much cost to be imposed if direction for affidavit is given? Say, please come.
I cannot say anything.
The petitioner seeks for a direction upon the respondent authority for supplying a copy of the deed number 366 of 2016.
Paragraph 8, Milord, after looking into this paragraph, I cannot make any submissions appropriate. I can
RBI
only
Act.
make a prayer to the extent that kindly save the client to get something. I can only make that. I cannot say anything.
Move before the section 54.
What can be given? RTI Act 2005. Stop. Paragraph.
কিসের appeal চাইছেন?
From the legal representation
করবেন
made on behalf of the petitioner annexed to the writ petition at page 47.
দিয়ে দিয়েছে। আপনি তো সেটা
Bracket লিখুন paragraph 8. It appears that the said deed was obtained by the petitioner online. Stop. A document which is available to the petitioner online can be used by the petitioner for any subsequent process, proceeding, not process, to be initiated by him. Stop. The prayer of the petitioner for passing order for supplying the subject deed under the Right to Information Act cannot be allowed by the writ court. Stop. It will be open for the petitioner to approach the statutory authority for relief if so advised. আরেকটা লাইন লিখে দিন তো, learned advocate representing the private respondent submits upon instruction that the subject deed number 366 of 2016 is no way connected with the sale of the subject property in favor of the private respondents.
I'm extremely grateful.
Passover matter ডাকুন তো, disposed.
Number 19 Passover matter.
Yes, Lord.
Petition.
Yes.
Last one, in this matter, you have to file a report, Lordship.
You were not there in the first place. That is the reason the matter had to be adjourned. Dekhi, report. What does your report say?
And Lordship, see a second page, Lordship, this is a report, impression as per local inquiry and other relevant documents ascertained that the candidate belongs to ST or an community, Lordship. Second page, Lordship.
Impression.
My lord, only I'm the petitioner, I'm the respondent. Only to harass this case, baseless case is my filing has filed. He is my tenant. He is not paying rent. He is disturbing over the 3 years, creating.
Yes.
May I place the fact? Thereafter, my lord said, my lord, it's a landlord-tenant dispute. My lord, what has happened? My lord, we are overstaying to oust us. My lord, they have taken a shrewd way. My lord, they are filing.
And now you have taken a shrewder way.
No.
What?
My lord, kindly hear me. My lord,
you go to
have-
the extent of challenging the certificate that has been issued in his favor.
My lord, they have filed cases after cases stating that they are scheduled tribe persons. My lord, I have annexed few documents. Your lordship would kindly come to page number 50, 51, 52.
Please come.
And 54. My lord, what has happened, my lord?
The petitioner is the petitioners are tenants of the private respondents. Respondent একজন আছে, ঠিক আছে? There are landlord-tenant disputes.
Yes.
Pending in between the parties. Stop. The landlord is taking steps against the tenants. Stop.
No step, my lord.
The-
No step.
No case has been filed by us.
No step.
আচ্ছা ঠিক আছে, লাইনটা কেটে দিন। The petitioners allege that the tenant, by taking benefit of the scheduled caste certificate issued in his favor,
Not tenant, we are the landowner.
is harassing the petitioners. Stop. The tenants, being the petitioners herein, lodged complaint against the private respondent before the subdivisional officer, alleging that the certificate issued in favor of the landlord/private respondent is illegal.
Based upon forged documents.
Illegal, based upon forged documents. Stop. Paragraph. A report was called for from the subdivisional officer. Stop. From the report filed by the inquiry officer, dated 13th of March 2023, it appears that a local inquiry was conducted and other relevant documents with regard to the status of the private respondent was investigated, and the authority opined that the candidate belongs to ST-ORAO community, ORAON.
May I submit one thing? my lord, may I summon? My lord, sorry for this interjection. My lord, the SDO is required to take up a hearing. My lord, that hearing subject to lordship's confirmation and subject to my learned friend's confirmation, that is yet to take place. How can SDO say that without taking up any hearing? That is coming from section 3 of SCST identification.
From the submission made on behalf of the parties, it appears that the landlord-tenant dispute has landed up before the writ court by way of the instant writ proceeding under Article 226 of the Constitution of India, challenging the caste certificate issued in favor of the landlord. The authority has come to a conclusive opinion that the candidate is a scheduled tribe candidate.
Kindly see this, that
is not inclined to enter into the not inclined to entertain the matter any further. The writ petition stands dismissed.
Section 3
Report
says,
is taken on record.
Section 3 says, my lord, a hearing is required to take place, my lord.
Call the next matter.
That hearing, my lord, has not taken place. My lord, may I get a copy of the report, my lord? Yes. My lord, may I get a copy of the report?
No, it's not your report. There is no requirement. You go and file proceeding before the competent forum.
Competent forum, that I have filed, that is the SDO. That is the SDO, that I have filed.
Yes.
Your Lordship, I'm applying for the petitioner.
Please.
Your Lordship, I'm filing the affidavit of service.
Yes. Who is your other side?
Your Lordship, this matter has been taken up by Honorable Justice Shobhajachi Bhattacharya.
Yes.
ASG from Delhi, senior advocate Vikramjit Banerjee has appeared in this matter.
When?
Though it's a long back, Your Lordship.
When? I do not see any order sheet.
Your Lordship, the order has not been recorded, but
Then?
But he appeared before.
You do not know the name of the learned counsel?
No, the advocate record was not because he was appearing online on that date, Your Lordship.
Something should be there. There is no. What is the proof of service? What is the challenge over here?
Your Lordship, the challenge I can explain, Your Lordship, but we have served. They have appeared on this matter, Your Lordship. If Your Lordship kindly, and we have tried to, as Your Lordship.
What is the matter about?
Your Lordship, kindly come. Your Lordship is, the ordering portion is on page 250, Your Lordship.
250?
250, Your Lordship.
Yes.
Your Lordship, this is the order, the impugned order, wherein the National Green Tribunal Eastern Zone Bench has passed an order. Special bench. The special bench has passed an order dismissing the 3 appeals. 4 appeals in altogether was filed by us, has been dismissed. Your Lordship, the main contention is that we have not been heard in this matter. And Your Lordship, there is a Supreme Court judgment to that effect. Your Lordship, this is a judgment wherein our case.
You are the Conservation Action Trust?
Yes.
You say you were not heard?
You're not heard.
I can see the appearances recorded.
Your Lordship, that's why we have filed a modification order to that effect also. Your Lordship, the modification, firstly, Your Lordship, kindly come to the cause list. Page 320, Your Lordship. 320, Your Lordship. Cause list for that day. Your Lordship, the 320 cause list will show then the first matter, Your Lordship, for filing rejoinder affidavit by appellant. The first matter, Your Lordship.
Yes.
On this date only, the final order has been passed by the court itself, constituting a special bench, which is not allowed by the Supreme Court. Supreme Court has categorically stated that a special bench cannot dispose of any matter of a constituted bench. So, Your Lordship, there are different zones has got different benches. And in this case, the zone, in the Eastern Zone, has to hear this matter. But the Eastern Zone has not heard the matter. A special bench has been created to dispose of this matter in the same day without hearing us. Now, Your Lordship, why we are saying we have not been heard? Your Lordship, kindly come then to our application. The order is in 329, but the petition is 324, Your Lordship. Kindly come to page 324 then. Your Lordship, we have filed.
It is such a detailed order and you say you have not been heard.
Yes, Your Lordship. That's the main thing, and it's in respect to the conserve the Andaman Nicobar Island, Your Lordship. A port is being constructed,
64 pages, and you say you are not heard?
Yes, Your Lordship, not heard. And that's why we have filed, this application has been filed on affidavit, we have filed it before the court itself.
No, you
Stating the
filed an application for modification.
modification.
What happened?
For modification, the stating that we have not been heard. You have, in the order sheet, they have noted you have been heard. We said we have not been heard. You have to write the correct thing. The court have passed an order stating that no, I will not go.
Then I am here to believe what the court has recorded.
Your Lordship,
And not believe
that's
your
why, Your
statement.
Lordship, the affidavit is required from the other side as well. Because, Your Lordship,
Who is going to file affidavit? The court will file
no,
affidavit.
court, not court. They are representing, Your Lordship. That day, both the sides were there. If Your Lordship, to get the correct picture of that day, Your Lordship, the other side needs to be present before Your Lordship to give you the correct picture. That's the only submissions we have to make. I can have a judgment to my effect just to show that Supreme Court has stated, the Supreme Court has stated that this cannot be allowed. Wherein the Supreme Court has stated why there's so much of hurry to dispose of an appeal, 4 appeals, suddenly in a day, constituting a special bench. Your Lordship, that's the only, if Your Lordship allows, I can again serve upon them through speed post to all the respondents. Because Your Lordship, the clear picture should come because this injustice has been done. And we are fighting for the people of the Andaman and Nicobar Island, Your Lordship, because this port, construction of this port will, at the end of the day, will affect the humanity.
And you want the court to
Your
take
Lordship,
your submission that the tribunal is passing order against public conveniences and everything.
Your Lordship,
Then?
the learned ASG was there on the previous occasion, though the order was not there. I don't know whether the video recording of that day was there or not. Before the Honorable Justice Shobhaji Bhattacharya, they have stated that something has been done, but they need to address Your Lordship on that occasion. Your Lordship was hearing the matter at length, and then Your Lordship said, okay, I will take the matter up in the second half. On the second half, the Lordship list collapsed and the Lordship couldn't reach to that matter. And that's why the order is not been recorded. And Your Lordship, that's why as the ASG was appearing from Delhi, I think they were not aware the matter has been listed time and again. If Your Lordship allows me, Your Lordship, I have filed my affidavit of service today, which shows that we have served.
The Union of India is not a party?
Yes, Your Lordship, we have tried to serve in the Kolkata, Union of India's Kolkata's office. They have refused to serve, stating the fact that as we have served on the first instance over the post, so they cannot accept it right now. We have to serve it again through post to all of them, because as the advocates who have been appearing in these matters have been appointed from the Delhi.
Please serve a notice. Anybody from the Union of India panel over here? Miss Anamika Pandey, she usually appears.
If Your Lordship orders, I will serve.
Give a notice to her.
I will.
Miss Pandey. None appears on behalf of the respondents. Let a notice be served upon Miss Anamika Pandey, learned advocate who usually represents the Union of India before this court. Released next Monday, 24th.
Deeply understood, Lordship.
Yes. This is regarding the information I sought under the Right to Information Act about how in respect of my property purchased, and they have retained in the land revenue records, BLRO, that police doctor Koptik Rokhito. I wanted to know on what basis they have recorded this. My property without paying any compensation. How can they write that this is police doctor Koptik Rokhito? Your Lordship will come.
Is it a vested plot of land? No.
I cannot find that. Lord, one thing, Lord, application have been made under RTI Act.
First appeal not.
That step has not been exhausted. Only one application that is appearing at page 78, that is P4. Thereafter, my Lord, to the first authority, then the other forums, first appeal and second appeal,
Nothing has been done. This is
nothing has been done.
2023.
Nothing has been done. This one.
The public information was ADM. This is ADMLR.
There is a first appellate, second appellate authority. You did not approach any of the authorities and you directly approached the
Earlier,
writ
it
court.
was it was filed before the BLLR, my lord, the public information of the BLR.
There is statutory remedy available in law.
Yes.
Why are you approach the writ court?
My lord, when they have, my lord, similar application, since the authority, public information officer at the office of the BLRO did not give any, but
As it is,
this
they
is
did
not a
not-
formal appeal. This is not a formal, but this was made, representation was made.
I'll send you over there.
As your lordship says, my lord, this is, they must inform me.
They must
what-
inform you, take the information from the proper authority. Why over here? আসুন তো দেখি। The petitioner seeks certain information under the Right to Information Act. Stop. It will be open for the petitioner to avail this statutory remedy in accordance with law. Call the 315 matter, 415 matter. whatever it is. Ajker item number 72, tomorrow as extension of interim order, at the top it should appear.
Obliged, my lord.